Welcome to this virtual hearing of the Public Accountability Committee's inquiry into the Transport Asset Holding Entity. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land upon which the Parliament sits, and pay our collective respects to elders past, present and emerging, those who are attending in the meeting in any form, as well as those who are viewing proceedings on webcast. Today's hearing is to be conducted as a fully virtual hearing that enables the work of the committee to continue during the COVID crisis in a manner that protects the health and safety of witnesses, the Secretariat and staff, and also members. I would ask for everyone's patience today if there are any technical difficulties with the online proceedings. If participants do lose their connection, they are reminded to just simply rejoin the meeting by the link that has been provided to them already by the Secretariat. Today, we will be hearing from the Transport Asset Holding Entity, Transport for New South Wales and New South Wales Treasury. The questions will be directed to the function, the purpose and the operation of the Transport Asset Holding Entity, an entity that has been created and has been the cause of some ongoing controversy. Before I commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's proceedings will be placed on the committee's website as soon as it's available from Hansard. In accordance with broadcasting guidelines, media representatives are reminded to take responsibility for what they publish. While parliamentary privilege applies to material within the hearing itself, it does not apply to comments made afterwards by either witnesses, members, or members of the public or members of the media. Committee hearings are not intended to be a forum to make adverse reflections on individuals. So I'd ask members and witnesses, if they could, to stick to the issues, not the personalities. There may be some questions that a witness can only answer if they have further material to hand, in which case witnesses are entitled to take a question on notice and have 21 days in which to respond. All witnesses are entitled to procedural fairness. It's a matter this committee considers to be of extreme importance, and it's also consistent with the resolution of the House. A few notes on etiquette for virtual hearings today. Could I ask committee members to clearly identify who questions are being directed to? And could I ask especially witnesses, when they commence a contribution, to commence with their name? That may feel repetitive on occasion, but it is of great assistance to Hansard. Could everybody please mute their microphones when they're not speaking, and remember to unmute them just before you begin your contribution. Members and witnesses are asked to avoid, if possible, speaking over each other. That does make it impossible for Hansard. Also, to assist Hansard, may I remind members and witnesses to speak as clearly as possible and directly into the microphones. I now welcome our first two witnesses from the Transport Asset Holding Entity. Could each witness please state their name, their position title, and take either an oath or an affirmation, copies of which have been provided to you by the Secretariat. We might start with you, Ms. Collin, then move to you, Mr. Crimp.
Good morning, Bénédicte Collin, CEO of Transport Asset Holding Entity. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thanks very much, Ms. Collin. Mr. Crimp.
Yes, Peter Crimp. I'm Executive General Manager Finance and Business Performance for the Transport Asset Holding Entity. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you both for your attendance today. You now have an opportunity, if you wish to take it, to make a brief opening statement.
Thank you, Chair, and I will take that opportunity. I'm very pleased to be here representing Transport Asset Holding Entity, an organization with an important role to play for the people of New South Wales. TAHI provides New South Wales with a strategic and dedicated asset owner for an extensive, high-quality portfolio that includes 4,000 of operational tracks, 1,500 electric and diesel cars, 300 square kilometers of land, 400 retail outlets, 1.3 million square meters of lettable area. These assets need a dedicated focus to unlock their value, accelerate precinct development, and build a portfolio generating sustainable revenues. TAHI was established as a state-owned corporation on 1 July 2020. It is at the very beginning of its journey. Operationalizing TAHI will require building a team with relevant expertise and capabilities, implementing the set of contractual arrangements that have recently been agreed with TFNSW, Sydney Trains and New South Wales Trains, setting up systems and procedures, devising the best capital structure to support a pipeline of property projects. I joined TAHI on 1 September. I bring 25 years of experience in transport operations, infrastructure investment, and setting up businesses. Notably, my last 2 roles as CEO of Keolis Downer and as investment director at CDPQ provide me with the requisite knowledge and skills for this role. Yet, having been in TAHI for only 1 month, it is clear to me that TAHI's role is not well understood. Too often, TAHI is described in terms of legal and accounting structures. This misses the point. This organization is all about ensuring we maximize the value of our transport assets, freeing up TFNSW to focus on strategy and rail operators to focus on providing better outcomes for public transport users and the New South Wales taxpayers. The New South Wales government is investing record amounts in transport system. This year, TAHI has a $3.4 billion of major capital projects to be delivered. As an independent state-owned corporation, TAHI will oversee that New South Wales regulated transport assets are delivered safely and efficiently while bringing new life and innovation into its unregulated business. I want to be clear on 3 very important things. Firstly, safety is the highest priority for TAHI board, me as the CEO, and executive across the organization. The creation of TAHI strengthened the transport safety arrangements. We operate in accordance with a pre-existing safety framework, but now provide an additional 3rd line of assurance within it. It is a key priority identified in our operating license and statement of expectation from the Transport Minister, to whom we are required to report on a regular basis. Secondly, this is a significant reform. It involves a lot of change, and change can be difficult. One of my priorities as CEO is to better articulate TAHI's role, and I'm very happy today to take the opportunity of this hearing to answer questions and explain how TAHI's operating model works. Thirdly, this is the beginning of a journey. Our execution will not always be perfect, and it will take some time to achieve maturity. We welcome recommendations as we progress our implementation roadmap, and we will report transparently. When I joined the organization a month ago, I shared with the team the values that I wanted the organization to embrace, and integrity and accountability were high on my list, as well as collaboration and commitment. This is how I intend to lead this organization and how we will be held accountable. Thank you again for the opportunity to appear before you today.
Thanks, Ms. Collins. Mr. Crimp, did you have anything to add?
No, I don't.
Well, then I might hand over to the committee members to commence questioning. I think Mr. Mookie might wish to kick off questioning.
Thank you, Chair. And firstly, can I thank the witnesses for taking the time to join with us this morning, and can I thank you as well, CEO, for the opening statement that you have made. Firstly, congratulations on obtaining the role. Secondly, what process was utilised to select you for this job?
Well, I can only comment on, sorry, should I say this is Benedict Collins, Chair?
Yes, but Ms. Collins, you have the benefit of a quite distinct voice, so I think we can just move on with your evidence.
Okay. Look, the process involved being approached by a recruitment firm and having interviews with the chair and the board on 2 or 3 occasions, if I remember correctly.
Thank you, Ms. Collins. When did the recruitment firm approach you?
If my recollection is correctly, would have been around February or March.
February or March. So you didn't put an application in that you were approached?
Sorry?
You didn't put an application in, you were approached?
I was approached, yes.
Was it February or was it March?
I think it was around late February.
Okay, thank you. Can I just ask a real simple question here, Ms. Collins? What is your remuneration?
My remuneration would be normally disclosed as part of the annual report. Since I started on the 1st of September, it would be next year. But to answer your question, my remuneration is $575,000. That's the total remuneration, and there is no bonus component.
So $575,000 and no bonus component. And that puts you at the equivalent of the Secretary of Treasury or thereabouts. Is that right?
I couldn't confirm, but I understand it's consistent with senior executives, the remuneration of senior executives within the New South Wales government, yes.
Thank you. And thank you, Ms. Collins, for being frank about that, because it has so far been somewhat
Mr.
of a
Mookie, I think it's Ms. Collins, singular. No,
Ms. Collins. Ms. Collins, sorry. Thank you for that. It has been somewhat of a secret. Colin, thank you. I appreciate it. I didn't mean to cause offence by getting people's names wrong. I have some understanding what that feels like. Can I just now formally, Chair, table the documents for the purposes of the committee here? And I understand, Ms. Collins, that it has been provided to you and your witnesses. Do you have these documents right now?
Sorry, which document are you referring to?
I'm referring to the one that's been provided to you that is called Tahi Tender 001.
I have received an email just about 15 minutes ago, just before the committee started, so I haven't had time to look at all the documents within this email.
That's okay. I will just take you through it, and then I'll read the relevant sections to you and just see what information that is available that you could provide, or perhaps Mr. Crimp could provide as well. Crimp could provide. That would be useful. The first document, which is Tender 001, is the instrument of appointment for your predecessor that was signed by the Treasurer and the Minister for Transport. And it says that Mercer Consulting conducted an independent work value assessment and remuneration report recommending a competitive remuneration package. Having considered the Mercer report, the Board of Tahi has proposed a remuneration rate. So is it the case that in order to determine your remuneration or the remuneration of your predecessor, Tahi hired Mercer Consulting to prepare a benchmark?
Look, as you will appreciate, I wasn't part of the organization, so I can't comment on the process that the board nor the remuneration committee went through. You will have, these questions would be better placed and directed to a chair of Tahi.
Sure. Do you mind, well, firstly, can Mr. Crimp add any detail there for us? Is he aware?
No, I wasn't involved in any capacity with the recruitment of the CE.
Sure. Well, look, I probably will take you up on your suggestion there, but do you mind potentially taking it on notice for me there?
Sorry, what's your question so I can take it on notice correctly?
Did Tahi hire Mercer Consulting to produce a benchmark in order to determine executive remuneration at Tahi? And if so, can they provide the report? Second aspect of this briefing to the Treasurer and the Finance Minister says that your predecessor will be paid towards the maximum end of the remuneration range proposed in the Mercer report to compensate for the short-term nature of the appointment, as is typical with contractor roles. Tahi is advised that the permanent CEO, once appointed, is expected to receive a lower remuneration rate. So it seems like your predecessor was paid more than you. Do you know what your predecessor was paid?
I don't know what my predecessor was paid.
Does Mr. Crimp have any further detail on that for us?
No, I don't.
Again, do you mind taking that on notice? Because I'd be interested to see, given that there's been 3 CEOs in this past 14 months since your organisation was created, are you able to provide us what the remuneration was for each of your predecessors, please, on notice?
Yes, we will.
Thank you. Can I just turn to another matter, to the next matter? But before then, I might just pause to see if there's any questions from my colleagues on that. Chair?
No, I think you can proceed, Mr. Moore.
Thank you, Chair. I just want to turn to the next matter. When was Tahi was formally established on 1 July 2020, correct?
Correct.
But work on establishing Tahi started years before, correct?
That's my understanding, yes.
It started from as early as 2013, is that correct?
I wasn't involved in that process, so I can't comment on the exact date when the process started.
Sure, but Mr. Crimp, have you been with Tahi since day one?
I've been with Tahi since the 1st of July 2020. Prior to that, I was also responsible for the accounting and finance for Rail Corp, which was Tahi's predecessor.
Yes, and you were involved in the project team inside Transport and or Rail Corp that led to the establishment of Tahi, that's correct?
I wasn't part of a formal project team, but because of by virtue of my role, I was often consulted or included in activities.
Sure. As a part of what was called the day one readiness, Tahi was meant to have certain policies in place on day one, that's correct?
Sorry, who's the question addressed to?
As a matter of courtesy, I'll address it first to Ms. Collin, but if she wishes to pass it to you, it's a matter for her.
Look, I wasn't present at the time, so I can't really answer your question.
Can I direct the question then to Mr. Crimp? As part of Tahi's establishment, it was required to have a whole set of policies in place on day one, that's correct?
There was a whole framework that needed to be put in place for the 1 July stand-up, including policies, staffing, the board, delegations. So there was, yes, a suite of process, policies, procedures, etc., that was available.
Yeah, thank you, Mr. Crimp. The one that I specifically want to ask you about is delegations, which you made reference to. And
Yes.
Tahi was required to have its policies in place for delegations, which I guess in layman's terms is who can spend what with what authority. Is that a fair summary of what we're talking about, Mr. Crimp?
Yes.
Thank you. To the CEO, what is your delegation for incurring general expenditure for the general work of the corporation?
There is a delegation in place, which provides some delegations in terms of expenses and capital spendings and authorities to enter into agreements.
Yes, and what is the delegation that you have?
I don't have a delegation sitting right with me. It's been embraced and endorsed by the board. It will be reviewed with us hiring new employees, but I'm happy to take that question on notice.
Oh, look, that would be appreciated. But for what it's worth, I do have it with me because, look, Tahi provided it to the upper house as a part of the call for papers. And just to be clear, it's for the people who might be following, it's the Tahi document, which is index number 5268. It is the Tahi Delegations Framework, July 2020, final draft, which was 23 June 2020. Ms. Collin, do you have an unlimited delegation to incur expenditure on behalf of the corporation?
No, I don't.
Why then? When did that change?
Sorry?
When did that change?
Again, I don't have the delegations with me, and as you will appreciate, I just started my role, so I'm not familiar with the entire documents and delegation.
But Ms. Collin, this is not a small question. You are the CEO of the organisation.
I think Mr. Crimp has something to add. We might go to Mr. Crimp and then I'll come back to you, Mr. Mookie.
Sure.
Yes, I'm happy to comment on that. So there was a proposed delegation framework that was ready for the 1st of July that was considered by the board in one of their initial meetings in July and was adopted by the board at that point. There are certain delegations that are described as unlimited, but there's constraints around those. They've got to be within approved procurement practices. They need to be within budget, and they need to be within the business plan as well, the plan as well.
Look, I appreciate that, Mr. Crimp, but can I just unpack that a little? So the framework that I'm referring to was adopted by the board on its inception sometime after July, is that correct?
Yes.
And it's still in place?
Yes, there have been some modifications to that though.
Yep, sure.
Since the time frame.
I do appreciate the context that you've given, Mr. Crimp, but I just want to go through some specific matters to the CEO because I don't think it's unreasonable for direct questions to the CEO of a corporation like this that manages $38 billion worth of assets to understand precisely what is the scope of her powers, and equally what is her understanding of the scope of her powers as well. Because I'm reading from a document here that says you have unlimited authority to incur expenditure so long as within the approved budget. Is that your understanding of your responsibilities, Ms. Collin?
Yes.
Yeah, and equally, you've got the ability to change expenditure on any non-capital project, don't you? To any limit.
Yes.
And equally, you have the ability to issue whatever tenders and obtain whatever quotes you'd like for whatever values you would like, so long as it's in accordance with procurement guidelines, which to be fair is what Mr. Crimp said. That's fair?
Yes.
And you also have unlimited authority to hire whatever set of consultants, professional services, labour hire personnel you wish to. That's correct?
For so long as they would be within procurement guidelines and policies of the organisation and within the budget.
Yes, but that doesn't seem to be as fettered. I'm reading from the document. It doesn't seem to be as fettered from the others. It seems like you've got whatever power you need to hire whatever consultants you'd like. That's fair?
Can I just add to that?
Please,
I don't think that's necessarily the case. I think there's a $2 million limit in relation to consultants, labour hire or professional services.
Well, I'm reading from this document and it says consultants, no limit CEO.
That was one of the changes, I believe, that the board requested as part of the stand up to the initial adoption of that framework.
And that happened in July last year, did it? Or
Yes, it arose at the first consideration, and then there was a report back to the board at a later stage.
yeah, sure. Thank you. I appreciate that, Mr. Crimp. I might just invite you, from the best of your recollection, Mr. Crimp, what other variations were made by the board to the delegations?
One variation was in relation to vesting orders. Vesting orders were initially a board reserved matter, but it became clear that there were routine vesting orders that didn't need to go to the board, so the board made a sub-delegation to the chief executive to undertake and approve certain vesting orders.
Is that the only other one you can recall?
No, there were others, but I don't have them. Pardon?
Perhaps on notice, do you mind providing us with some further information as to what other variations were made by the board?
Yes, happy to.
Thank you, Mr. Crimp. That's just in respect to the delegations as they apply to operating expenditure. I want to turn now to capital expenditure, which, let's be honest, is the core of what Tahi does, as you make clear in your opening statement. It says here that approve expenditure of money in relation to capital expenditure funding. You have no limit, Ms. Collin. Is that your understanding?
Capital expenditure would be set within a budget, which is approved by the board, which is informed by a series of documents and plan provided by each of the operators, reviewed by TFNSW, and this informs our plans.
But you have no limit.
Within that budget, which again has to be approved by the board, I have no limit.
Sure. And that applies as well to any variations in a project, that's correct as well?
Any substantial variation to the project, again, I've just started my role, I think would need to be discussed at board level.
Okay, I appreciate that. The reason I ask this is because I'm not aware of any person in the public sector who has this level of authority. Can you explain to us how was this created and what organisation was this benchmarked across? Do you have any information on that?
Again, I just joined the organisation, so I can't comment on the formation of Tahi nor benchmark with other organisations. I think these questions would be better directed to Treasury, who was intimately involved in the setting of this organisation.
Was this decision made by Treasury or was it made by Transport?
I'll just take a point of order. It's my standard point of order with Mr. Mookie.
Yeah, I get it. Sorry.
Repeated times where he's spoken over the witness. If he could just throttle it back by 10%.
Thanks, Mr. Khan. I think just a slightly longer pause to allow a witness to complete their thoughts, Mr. Mookie.
I appreciate that.
Excuse me, can I just add also that I believe the capital delegations were amended at the same time as the operating delegations. So the same restrictions were in place in terms of both within budget, within plan, and within procurement guidelines. So if it wasn't within those limits or criteria, then there was a sub-delegation of, I believe, 5 million from memory.
Mr. Crimp, would it be possible for you to provide the current delegations with any amendments to the committee?
Yes, I've already taken that on notice.
Thank you.
Hi, Ms. Collin. Before, as my colleague pointed out, before I perhaps rudely interrupted you, you were making a point that these questions were better directed at Treasury, for which I was just asking you, was it, to your best of your knowledge, was it Treasury that determined this policy?
Again, I wasn't involved in the setting up of TAHI, so I can't comment on who was involved in the development of that policy.
Sure,
So
thank
again,
you.
just one question
Please.
in relation to this. Ms. Collin, the statement of corporate intent, which I'm sure you're familiar with, is that right?
Yes.
It provides that TAHI adheres to a modified version of the commercial policy framework as agreed with New South Wales Treasury. What are the modifications? Do they provide additional leniency from the usual strictures?
Again, I'm happy to speak to that.
Well, I might ask Ms. Collin first, and then we'll come to you, Mr. Crimp.
I will direct that question to Mr. Crimp, if that's okay.
So in terms of the modification of the commercial framework, there were certain items that Treasury deemed didn't need to take place in the first year of operations. So, for example, we were exempt from quarterly reporting, as an example. There are other items that did apply on the 1st of July, but there were others, as I said, were exempt in the first 12 to 18 months.
What were the exemptions, Mr. Crimp? You would obviously be aware of them.
Yes, the one I've mentioned a moment ago in relation to quarterly reporting. There was another one with respect to state taxes, and I would have to take on notice probably the other delegation, other framework items that were exempt in the first year.
Did any of them relate to delegations?
I don't believe so.
Sorry, Mr. Mookie.
Don't worry, Mr. Chair, thank you. It's actually was my next topic, but before I complete on this one, I was just going to ask Mr. Crimp, who was perhaps more involved in the establishment of TAHI. I've not come across any state-owned corporation that has had delegations policies which seem to be this loose. Can you shed any light into who created this policy and how?
There was an original draft that was presented to the board as part of the stand-up. I don't know the exact origin of that. It was probably through one of the project teams that were working on the stand-up. But as I said, the board modified those prior to adopting them.
Well, I think you said that they modified them after adopting them, but fair, they were modified. But did the board have any regard to ICAC's policy on procurement here, which contains multiple warnings about the dangers of unlimited delegations?
I can't speak for the board, sorry.
Did anyone in the TAHI organisation provide such advice to the board?
I'm not aware of that.
Did anybody, to the best of your knowledge, given you were liaising at the time, when I say you, I mean TAHI, was liaising heavily at the time with Transport and Treasury, did anybody in Transport or Treasury, to your knowledge, say that having the head of an organisation like this, as you effectively described yourself, is in startup mode, to invest unlimited authority to acquire, subject to the parameters that you've stated, perhaps would breach some of ICAC's guidelines and policies?
There were always the constraints around expenditure having to be within budget, for example.
Thank you. I might now just pause there, Mr. Chair, and just invite any other questions from my colleagues on this topic before we get to the one that you raised.
No, I think you can proceed, Mr. Mookie.
Thank you. As the chair pointed out, you well, as the chair, let me restart that. You are a state-owned corporation, correct?
Correct.
As a result, the Treasury's commercial policy framework applies to you. That's correct.
Yes.
And what's your understanding of what the commercial policy framework is, Ms. Collin?
Look, again, I just started my role, so I'm in part of being educated on these documents. I operate my role within the delegations that are given by the board and my shareholders. So as I'm not familiar necessarily with the extent of all documents, if that's okay, I'll take your questions on notice.
Look, I understand that.
I could add to that.
Just before we do, Mr. Crimp, just to follow up on Ms. Collins' answer, I understand you say that you answer to your shareholders. Your shareholders, who are they?
The Treasury and the Minister of Finance.
Thank you. And the Treasury is is it your understanding that the Treasury is the department that applies the commercial policy framework?
Yes.
Thank you. Mr. Crimp, I think you wish to add some detail there.
Yes, there's a series of TPPs, as they're described, that constitute the commercial policy framework, and some of those were deemed to apply on the 1st of July. Others, as I said earlier, were deferred given the setup of Tahi.
Sure. Is it perhaps the right summary of the commercial policy framework? Would you agree with me that it is a suite of policies that seek to replicate within government business disciplines and incentives that lead towards efficient commercial practices?
That doesn't sound unreasonable.
Indeed. And can I just be clear here? When Tahi was being formulated inside both the Treasury and the Transport, it was originally envisaged, was it not, that the commercial policy framework would apply to Tahi on day one?
With certain exemptions and exceptions based on the nature of the stand-up.
When did that caveat, Mr. Crimp, arrive? Because I'm inspecting multiple documents from 17 and 18 that make it very clear that on day one, Tahi was expected to be compliant with the commercial policy framework. So when did it change to it should be compliant with the commercial policy framework to it should be compliant with the commercial policy framework subject to the conditions you just said?
It was signed off in the original brief, which was tender document 002 that you distributed this morning.
Indeed. And so that tender document 002 is the brief that was signed by the Treasurer and the Finance Minister as the two ministers, well, actually as your voting shareholders, but equally the Treasurer is the administrator of the commercial policy framework. And the Treasurer gave you this exemption from the commercial policy framework on the 29th of June 2020. Is that your recollection?
That's the date that one of the shareholders signed. The second one signed on the 30th.
Yes, the day before you went into existence. That's correct.
Yes.
So the day before you're created, the Treasurer is already exempting you from governance policies. Is that fair?
That would be sorry, I was going to say.
Sorry.
We'll start with you, Ms. Collin, and then we'll go to you, Mr. Crimp.
I was going to say these questions would be better directed at Treasury, who actually was involved in the signing of these documents.
Well, I'm wondering whether or not Tahi requested it, or the interim Tahi team requested it. Did the Tahi or any people involved, Mr. Crimp, are you in the interim who are in the transition team, I think it was called, request this exemption?
I have no knowledge of that, no.
Okay. What were your understanding of the reasons why the Treasurer provided you with this exemption?
In certain circumstances, there were items that probably didn't add value in the stand-up nature. So again, I could come back to quarterly reporting. That was an exemption for the first 12 months. As Tahi went through that transition.
So is it the case that the Treasurer exempted you because requiring full compliance with the commercial policy framework from 1 July 2020 would place an administrative burden on the interim board that would run counter to efficient commercial practice?
I don't think, Mr. Moki, that's what Mr. Crimp said.
No, I'm not suggesting that he did. I'm asking him now, and to be fair, Ms. Cole, I'm asking to you. Was the actual reason, not the reasons Mr. Crimp gave, but was the actual reason why Tahi got this exemption was because requiring full compliance with the CPF from 1 July 2020 would place an administrative burden on the interim board that would run counter to efficient commercial practices? Again,
I wasn't involved in the decision making of this exemption, so I can't comment on the intent. What I would certainly refer you to my opening statement, which is we are at the very beginning of a journey, and we need to establish the appropriate systems and procedures to comply with this policy. And I appreciate it's the beginning of the journey.
Sure. Does Mr. Crimp wish to answer, perhaps provide any context to that question?
you're quoting directly out of the document that was signed by the Treasurer. So
I am.
yes, on the basis that that was in the document, I'd have to agree.
So, Mr. Cribb, it wasn't the reason why you gave. It was, in fact, the inference that I'm drawing from this, and please tell me if I'm wrong, the inference I'm drawing from this is that you're exempted from a powerful form of corporate governance that applies to every state-owned corporation because basically you weren't ready to comply.
No, I think if you read the full sentence, the preceding part of that quote that you gave us was that after establishment, Tahi's nature and functions will change significantly as it transitions to its full mandated scope. And then it says additionally requiring. So I think the context still stands that it is more than just the burden on the board.
Okay, well, I'll take you at face value. Can you explain to me how has Tahi's nature and functions changed significantly in the last year?
We have been through a transition from a PNFC to a state-owned corporation. It is in itself a transition.
If I can, please, Ms. Collins.
Sorry, if I can add to Mr. Scribb's response, all the work that has been done in 2020 and 2021 was really embedding the operating model, which starts with an operating license, which is granted by the Transport Minister, which specifically articulates what we can do and what we can't do, and specifically articulate that we can't be a rail operator nor a rail maintainer under the safety national law. We have a statement of expectation, which is also issued by the Transport Minister. And over the course of the last few months, Tahi entered into 5 key agreements, which really embed its operating model. So there was a track access agreement signed with Sydney Trains and New South Wales and Transport for New South Wales. There is a license and HSE maintenance agreement, which also has been signed with Transport for New South Wales, Sydney Trains and New South Wales Train. These 2 agreements are key because they determine the revenue model of Tahi, as well as the Project Property and Development Agreement, which looks after how we develop capital projects and property projects, and Corporate Services Agreement. So it's fair to say that the operating model of Tahi has significantly evolved since the 1st of July 2020.
Well, I accept to you that you are implementing the model that you were meant to. Whether you consider that to be a change in function is a different question. But trust me, Mr. Collin, we will turn to some of the matters that you raised later on. Rest assured, I appreciate that, though. But look, the concern that I have is this: is that actually, before I say that, Mr. Cribb, you made the point that you were exempted from the requirement to pay state taxes. Is that correct?
Yes, I think for the first 12 months, there was an exemption as part of our stand-up in relation to state taxes other than in areas where we leased or licensed.
Yeah. We're talking about the tax equivalency regime, aren't we?
No, I was talking about state taxes.
Oh, which taxes are you exempt from?
Land tax, for example.
Right.
That was an exemption in our founding governance.
And why were you given that exemption?
Pardon?
Why did you need that exemption?
I can't comment on why we need it. I just know that that was part of the stand-up.
You've got billions of dollars worth of land, don't you?
Yes.
And you're exempt from paying land tax on it as a commercial enterprise now?
No, only in the first 12 months. And where we derive revenue from that in terms of leased or licensed premises to non-rail operations, then we are still liable for taxes. Okay,
so you're paying land tax from this year, are you?
That same exemption is actually carried forward.
So when are you going to be paying land tax?
We are paying land tax, but only on a limited category of our portfolio.
And when will you be paying land tax on all your portfolio?
That is still 18 months away, I believe.
Why is that?
Some of it comes back to the ability to get valuations of some of that land from the valuation office.
What do you mean?
Can I just ask what the value of that exemption is? over each fiscal year while it's in place?
I haven't quantified that value.
Can you give us a ballpark figure firstly?
No, I'd be speculating at this stage.
Would you take
Yes,
that on
yes.
notice?
Yes.
Mr. Crimp, the statement of corporate intent states that the land values for the rail operations are some $11.1 billion, and the land for other property portfolios is $300 million. Is that statement of corporate intent accurate?
It would have been at the point in time.
So you should be readily able to determine the land tax given that you have the values set out in the statement of corporate intent.
That
Shouldn't
may
you?
not be the same value, though, that the Valuer General holds in their records.
The Valuer General's records are public. I could find out what the value of your land is right now. What's to stop? What is the issue that you've got in getting your land valued?
It's aligning the portfolios and the titles with the Valuer General information.
Mr. Crimp and Ms. Kong, given that your core purpose is to hold assets and 1 in 4 of the assets you own is land, are you seriously telling us you do not know what the land portfolio is worth for the purposes of land tax?
The way sorry, Peter, go ahead.
We know what the value of the land is. It's valued regularly as part of our normal financial statement preparation.
Sorry, Mr. Crimp. Sorry, Mr. Crimp. There was a delay. I thought that you had stopped.
But Mr. Mookie, not quite long enough a delay. Mr. Crimp, we might just allow you to answer it, and then Ms. Collin, if you wish to add anything at the end, the opportunity will be available for you too, Mr. Crimp.
So, as I said, we have valuations of our land for the purposes of our financial statements. There is an exercise underway matching that on a title by title with the information that the Valuer General has in their records.
Is the actual reason why you were given this exemption was because if you had to pay land tax, you'd have to pass it on to your customers, wouldn't you?
It would depend under the Leases Act whether or not there had been sufficient notice provided to those rental customers.
No, I'm not just talking about the rental customers. You'd have to recover the full economic value of that land and the tax, and you'd have to charge New South Wales Trains and Sydney Trains more, wouldn't you?
I don't believe we would be charging them any more. The lease and license arrangements would already reflect that.
No, but IPART would consider that a cost that needs recovery, wouldn't it?
Depends which method, which agreements and which type of assets you would consider, Mr. Mookie. Are you talking about regulated assets or unregulated assets?
Both, actually. But to be very clear, I just want to put this to you. You can deny if you disagree. It was the actual reason you were given this exemption was because in its absence, you would have to recover this cost from your main customers that would have impacted on the state's budget.
No, I don't believe that's a correct statement.
Okay. Was all the land subject to evaluation by Joan Lang LaSalle?
No, the valuation was done by Colliers, and there was another firm that looked at the land valuation in the Country Rail Network.
Did they tell you what the value of the land tax exemption was?
That wasn't part of their mandate. They were asked to value it in accordance with accounting requirements.
Okay. Did they? Okay, I'll move on from that. I might just pause there and ask if any of my other colleagues have any questions on these matters.
I just wanted to ask, just on that point about if you don't believe that that land tax exemption was given in order for you not to have to pass that on to entities that would end up having to pay it, it would appear on the budget. Why do you think that the land tax exemption was given?
Probably more for administrative reasons in terms of having been able to match the respective land values with the Valuer General.
Could you explain that a bit more? What do you mean by that?
there is a piece of work that is required and is underway to validate the land for the purposes of land tax purposes.
So it was too difficult to work out the value, and so that's why you're not taxed?
It was probably lack of information more than, well, and difficult based on the information available.
No one else gets that sort of exemption when it's difficult to value a thing. Does that not strike you as unusual?
That was already in the founding legislation. So it was recognised, I think, at the time that there were implementation issues.
Thank you.
When your assets were owned by Railcorp, why didn't they know the value of this in line with the value of general valuation?
Railcorp was exempt from land tax.
Fair enough. I'm just going to move on now. I'm just going to ask some questions about your finances, if you don't mind. Is it the case that you expect Sydney Trains and New South Wales Trains to be your biggest customers?
We've got, as I pointed before, we've entered into track access agreements and license and electricity agreements with Sydney Trains and New South Wales Trains. That's correct.
Yes, but the question specifically is, do you consider them to be your biggest customers?
They would be driving a significant portion of our revenues, yes.
How much of your revenue do you think they would be driving?
Look, I can't second guess, but it would be, as I said, a very significant importance of our revenues.
Mr. Crimp?
At the moment, it would probably be around the 90%.
So 90% of your revenue is coming from two customers. That's right, New South Wales Trains and Sydney Trains.
As part of our revenue sources, yes, but we also have revenues from other infrastructure assets and
Yes, I know.
revenues from property and retails.
Sure, and accept that, Scott. Thank you. But it is the case, we're just talking about 90% are coming from two of these customers. How do you decide how to charge them?
Well, there is a methodology under the track access agreement, and for which we followed the IPART methodology, and there is the same methodology, even though not mandatory, has been applied for the license agency and maintenance agreement.
So it's perhaps, to paraphrase, and tell me if I've gotten this wrong, you've basically mimicked what you think IPART would say you should charge them.
Well, I didn't say mimic.
True, I'm asking you. But
I said because it's for the track access agreement, we have to comply with the methodology which is recommended by IPART. For the unregulated assets, which are the subject of the licensee agent maintenance agreement, we followed the same methodology.
And you followed the same methodology that I think, thank you, that clears that up. Did you obtain any consultant support to help you follow that methodology?
I wasn't involved in that process, so I might direct the question to Mr. Crimp.
Mr. Crimp.
Sorry, could you repeat the question, please?
Did you utilise any consultants to assist you with following the IPART methodology?
There was some assistance as part of a broader engagement around the construction of what a building block approach would look like with respect to both the return of and return on assets.
Which consultant?
When BCG were engaged, they provided some insight into that.
Yeah, we'll get to the BCG engagement.
In conjunction with our own people. And then there is a access model that's been updated, and that was done with some consultants as well.
Who are those consultants?
That was KPMG.
And when was KPMG providing you with that model? What did you call it, Mr. Crimp?
An access costing model.
An access costing model. When did KPMG provide you with the access costing model?
It would have been in the first 6 months of 2021.
First 6 months of 2021. And who from KPMG did that?
As in names?
Yes, please. The lead partner,
The lead partner on that was Heather Watson.
Heather Watson. And how was Heather Watson chosen?
In prior years, KPMG had developed a model for the Tahi project team that would have helped inform some of that activity. So the model was already established, and it was getting KPMG to update that with most recent information.
Mr.
Where
Crimp,
did Miss-
could I ask you, sorry, Mr. Crimp, could I ask you to be a little more specific about when that was provided? You said the first 6 months of this year. We're only talking about very recent history. Could I ask you to be more specific?
Oh, sorry, I meant this calendar year.
Yes. So when you said the first 6 months of this calendar year, we're still talking about very recent history. And I think it would assist the committee if you could be more specific.
Look, I don't recall the exact start date of that exercise. I'd have to take that on notice.
When was it delivered, Mr. Crimp, is the question?
We had, again, I'll have to take that on notice. It was around the May timeframe, I believe, but I will take that on notice.
So May, so let me just be clear here in the timetable. Firstly, was Miss Watson the first KPMG partner to assist you with the access model?
No.
Who was?
I don't recall who the lead partner was in the previous engagement.
Sure. And so that lead partner stopped. When do you recall when that person ceased?
Well, it was a one-off exercise done in earlier years.
Earlier years. Was it performed between 1 July 2020 and 31 December 2020?
No, the model was originally developed in, I'd be speculating. Let me take that on notice when the original model
But I'm
was developed.
speaking specifically about Tahi, not transport. In between 1 July 2020 and 31 December 2020, do you have any recall as to who the lead partner was from KPMG that was assisting Tahi with the development of the access model?
In that time frame, I said it was under the supervision of Heather Watson.
And how, you never actually told us how Miss Watson was selected by Tahi.
It was on the basis that they had already developed a model, and it was sensible to continue to use that model and get it updated to reflect the needs going forward.
Did Miss Watson obtain this work without a tender?
That would have been sole sourced. Yes.
Why hasn't Miss Watson's engagement by Tahi been published on the contracts register?
I believe that engagement has been.
I couldn't see it. So if you can provide us the date it was published, and perhaps if you're aware the date it was taken down, if it's the case that it has disappeared. But in terms of all the Tahi contracts, it did not appear. And how much was Miss Watson paid by Tahi?
I will have to take that on notice.
Do you have, do you have an estimate as to the range?
Not off the top of my head. No, I'll take that on notice.
Did anybody from Treasury tell you to hire Miss Watson?
No.
Did anyone from Treasury provide any reference of Miss Watson to Tahi or its board?
In relation to that piece of work?
Yep.
No.
Did you ever check whether Miss Watson had any relevant conflicts of interest?
In relation to this particular exercise?
Yes, because this is the crucial aspect of the model that determines how much you charge. Did you ever check whether Miss Watson had any conflicts of interest, especially with Treasury?
I don't recall.
Is it the case that Miss Watson was also engaged in providing advice to Treasury at the same time?
She was providing accounting advice, I believe, yes.
So at the same time Miss Watson was advising Treasury on the accounting treatment, she was advising you on how much to charge New South Wales Trains and Sydney Trains.
They were updating a model that was had previously been developed by KPMG.
Sure, but I'm putting it to you. You, from 1 July 2020, become an independent organisation that's meant to be independent of government. You never checked to see whether Ms. Watson had a conflict of interest, given that she was engaged by Treasury. And to be fair to Treasury, they have described her in budget estimates as a hand-picked consultant by them, and you also sole-sourced it. Does that not strike you as being potentially a conflict of interest?
The nature of the work in terms of updating the model was done by other KPMG staff that were familiar with that from previous activities, and that's why they were selected.
Who actually signed off on that decision? Was that a decision made by the CEO or the board of Tahi?
I believe it would have been the CE.
Which one of the three?
It would have been the first CE.
Is that Ms. Hayes? Anne Hayes?
Yes.
Thank you. How much are you charging Sydney Trains and New South Wales Trains this year?
Mr. Mukivis, our agreements are under review at the moment as part of our audit. So I'm afraid it wouldn't be appropriate to answer that question. So we will take it on notice if that's okay.
Well, you can. I welcome that, Ms. Collin. But look, I'm just going to read from your statement of corporate intent, which, if you've got with you, I'm reading from page 6. And it says that you expect your earnings before interest, tax, or actually in accordance with the agreement that you signed with the Treasurer and the Finance Minister, your earnings before interest, tax, depreciation and amortisation this year is meant to be $779.3 million. That's your understanding?
Yes.
Are you on track for that figure?
We've entered, as I mentioned before, we've entered into 2 key agreements with Sydney Trains and New South Wales Trains and Transport for New South Wales, which are the track access agreements, which generate revenue for access to our tracks, as well as the license agency and maintenance agreements, which generate revenue from licensing unregulated assets such as stations and rolling stocks, for instance. So yes, we are on track.
Great. I'm just going to do some back of the envelope calculations. Given that Mr. Crimp has said that you expect 90% of your earnings to be coming from those 2 customers. Granted, revenue is not the same as EBITDA. EBITDA is lower than revenue. So we can infer from that that you're likely to be collecting close to 700 to 750 million from just those 2 entities, correct?
Yes.
Yes. And the following year, 2022, 2023, you're expecting to realise almost exactly the same levels of earnings. That is, this year you're expected to earn 779.3 million, and then next year you're meant to earn 779.6 million. So it's basically the same, correct?
Yes.
So we can infer that therefore the charges that you're applying for them, which I presume stem from your choice to follow the IPART methodology, leads to the conclusion that they have to pay circa 700 to 750 million for the next 2 years. That's correct?
That will depend on our capital base and capital program, but yes.
So it's not an unreasonable inference, is it?
No.
Thank you. What happens in the years after that?
Our access, the track access agreement will build, as I said, on the methodology of IPART and our capital base, and that will depend on the capital programs, which will be approved by Tahi. And
Indeed, but Mr. Crimp's, the access model that Mr. Crimp was describing allows you to forecast how much you will be charging those 2 entities in the succeeding years. What does that model say New South Wales Trains and Sydney Trains should be paying you?
again, the methodology is based on our capital programs and informed by capital programs by New South Wales Trains and Sydney Trains, on which we will be paying charges. So it will be updated. Mr. Crimp, would you mind providing an answer in terms of how the adjustment works based
Yeah,
on our
so-
capital base.
And can I just clarify that the KPMG access pricing model looks at what the floor is and what the maximum allowable revenue is. It doesn't stipulate a price. The price was a negotiated price based on an agreed methodology. So the model itself doesn't generate an answer in terms of pricing. But our methodology was to look at our existing assets and look at the return of and return on those assets, and then also factor in over the forward estimate what the incremental investment is in both regulated and unregulated assets, which in turn attracted a fee and charge for that future investment.
Thank you, Mr. Crimp. I appreciate that. Trust me, we will get to that access methodology and the difference between the floor and ceiling price shortly. I have one more question to ask you before I invite my colleagues to take over. In your statement of corporate intent on page 7, it says that you're meant to have satisfactory completion of a 10-year strategic business plan by 1 July 2021. Do you have your 10-year strategic business plan in place?
It is in the process of being adopted by the board. So yes, that work is well progressed.
So therefore, that plan would tell you how much you'll be charging those two entities in the years going forward, given that they are your massively, by far, your biggest customers. So I will invite you again for the last time before I pass to my colleagues. Do you wish to tell us what's going to happen in terms of how much Sydney Trains and New South Wales Trains will pay you when we get beyond the forward estimates?
As I repeated before, our financial statements are currently being audited. They are informed by our business plan. So there'll be an estimate in our next statement of corporate intent, and the amount of charges will be reviewed regularly based on the capital programs that is being developed.
I'll pass to the chair.
Oh, thanks, Mr. Mookie. Whilst we're on the statement of corporate intent, Ms. Collin, Mr. Crimp, you would agree that complying with that is essential for your organisation, complying with the statement of corporate intent? Do you agree that it's essential? It's not negotiable. You have to comply with it.
Yes.
Well, can you tell me what the key risks and emerging contingent liabilities are that you determined could materially impact the current and future results of Tahi?
Well, Tahi is a state-owned corporation, and so it derives revenue from a range of customers. We've mentioned the two big ones, which are New South Wales Trains and Sydney Trains. So it's essential that we enter into firm agreements with those two customers. We've got also revenues from other infrastructure assets and third-party operators on our tracks, which we need to firm up, as well as revenue derived from our retail. So any major amendments to this agreement would have an impact on our revenues.
Well, so that they are risks because you have a narrow customer base. Is that one of your points? Is that what you're trying to describe, Scott?
I'm saying that it was very important as part of the development of the operating model that we firmed up these agreements with New South Wales Trains and Sydney Trains.
Well, Ms. Collin, you are required under the statement of corporate intent to fully disclose all of the known key risks and emerging contingent liabilities. I haven't seen that done anywhere. Can you please now fully disclose all known key risks and emerging contingent liabilities? And in doing that, can you tell us who you've disclosed them to so far?
Sorry, I will have to take that question on notice. We are in the process of developing our enterprise risk agreement and our risk management frameworks. That work is certainly underway, and we intend to report it when we are in a position to do so.
Ms. Collin, they were required to be disclosed last financial year under the statement of corporate intent. You were required to disclose, your organisation, I accept it was before your time, so I'll go to Mr. Crimp. You were required to disclose all emerging contingent liabilities last financial year, fully disclose them. So Mr. Crimp, I'm asking you now, what are they?
We disclose contingent liabilities as part of our annual report each year. So one contingent liability that does get signalled in there is the risk of contamination across our network. In our half year, we also identified that COVID represented a risk to our future revenue streams, and that will also be incorporated into our financial statements as a risk as well.
Have you disclosed as one of your risks what was identified by the Auditor General, that there's an inherent conflict between the objectives of a commercial return and maintenance and safety measures? Have you addressed that?
That is one of the steps we've taken to address the 4 recommendations from the Auditor General. As you'll be aware, we appeared at the Public Accounts Committee a fortnight ago and spoke to progress that had been made against those 4 recommendations, and have, from our perspective, met the needs and the requirements of those recommendations.
Well, I'm going to ask you, Mr. Grimm, to provide with some specificity where it is that you have fully disclosed the key risks and emergent contingent liabilities, and can you provide details of those key risks and contingent emergent liabilities to the committee, other than the general terms in which you've just spoken then about COVID and the like?
Those are, from our perspective, the key risks.
That's it. COVID, and you've got a narrow customer base, and that's you say that's complying with the statement of corporate intent. Is that seriously your answer?
And contamination.
And contamination. You're holding $40 billion of assets in a highly politicized environment where you didn't have agreements even with your key customers. There are major tax considerations going forward. You don't have an answer on land tax, and none of that is being put forward in your answer about fully disclosing contingent liabilities and key risks. None of that's part of it. Is that right?
Can I answer that question, Mr. Sugar?
Please do, Ms. Nolan.
As I said, I just joined the organization a month ago, but I can tell you in the months that I joined the organization, we are in the process, and perhaps from your perspective, it's late in the process, but we are in the process of adopting a risk assurance frameworks which identify in much more granularity the risk that the company might be exposed. That risk assurance framework is not yet completely approved and developed, so it would be premature for me to comment, but I can reassure you that that process is underway.
Could
Well,
I just,
yeah, Ms.
sorry.
Port.
I was just going to jump in there on the maintenance aspects. So just in terms of maintenance, Tahi is ultimately responsible for the maintenance of the assets. Is that correct?
Tahi is not ultimately responsible for the asset. It is maintenance of the assets. The ongoing maintenance is the responsibility of accredited parties, such as Sydney Trains and New South Wales Train. The budget for maintenance rests with Transport for New South Wales. And Transport for New South Wales is responsible for making sure that any critical safety items resulting from maintenance is funded. So we don't have responsibilities with the budget of maintenance. And that is to comply with our operating license.
So just to clarify, so Transport for New South Wales is responsible for identifying the maintenance required. Is that correct?
That is not what I said. Or if I said it, I'll take it back. Sydney Trains and New South Wales Trains, which are the accredited party for the maintenance of the tracks and networks, are responsible for developing their asset management plans and the maintenance requirements and the funding requirements of the maintenance.
Who is responsible for determining how much money is spent on maintenance?
These are Sydney Trains and New South Wales Trains would come to Transport for New South Wales, and Transport for New South Wales is responsible for seeking the appropriate funding for the maintenance of these assets.
Does Tahi pay for the maintenance of any of the assets in any way through any arrangement?
For regular maintenance, it doesn't. Not for the regulated asset, not for the assets that are the subjects of the operation and of the networks. We pay maintenance for our property portfolio, which is retails, for instance.
So, okay. So if there is a maintenance issue, from a Tahi perspective, although you are the owner of the assets, the maintenance cost is not something that's borne directly by Tahi. Is that what you're saying?
Yes.
Thank you.
Just
Sorry,
to follow-
Mr. Wilkie, just on that, and then I'll hand to you to take us
Please.
through the end. The Auditor General describes those arrangements as legacy arrangements in the context where there were no access fees being paid by Sydney Rail. Mr. Crimp, is it fair to describe those maintenance arrangements as legacy arrangements flowing from the arrangements that have been in place with Railcorp?
That's not a phrase I would have heard or used in relation to that.
Well, I'll read from the Auditor General's report, which I'm surprised you haven't read, Mr. Crimp. It says, however, current legacy arrangements from Railcorp have transitioned to Tahi, where no network access fees are paid by these rail operators. Maintenance expenses for the Tahi rail assets continue to be paid by the public rail operators. Are you saying that's the first time you've read or heard that report from the Auditor General?
Can I just point that the report from the Auditor General was issued at the back of 2020. We've now entered into new agreements with Sydney Trains, New South Wales Trains, and Transport for New South Wales Trains.
Thanks, Ms. Collins. Now, Mr. Crimp, could you answer my question?
On the 1st of July 2020, the rail services contract that was in place between Transport, Railcorp and Sydney Trains continued in its present form. That recommendation from the auditors was that we get commercial agreements in place, which have now been done effective the 1st of July 2021.
So now access fees are being paid. Are the Sydney Trains paying both access fees and the maintenance costs, paying both of those to Tahi? Is that what the arrangements are now?
They don't pay maintenance to Tahi.
Or are they undertaking maintenance expenses? Sorry, Mr. Crimp. So they're paying access fees for your assets,
Yes.
but they're also paying to maintain your assets. They're double paying.
They're not double
No.
paying. They're not paying maintenance to Tahi. That's what Mr. Crimp is saying.
No, they're paying to access your assets, and they're also paying to maintain your assets. They're paying the expenses themselves to maintain your assets. They're double paying you.
That's not correct. In terms of the building block model that we've developed, it takes into account the fact that they are paying the direct costs, which they're funded for. The access charges that are generated by Tahi only relate to the depreciation on that asset, so the return of the asset and the return on, not the direct cost of maintaining or operating those assets.
I'll pass over to Mr. Mookie.
Thank you. Fair. Can I just refer you, look, I might direct this, Ms. Collins, to Mr. Crimp, perhaps, given that he raised the issue of the floor price and the ceiling price before. If you can I just refer you to what's I've labelled Tahi tender document number 3, which is KPMG Tahi long-term operating model assessment, 5 November 2020. If you go to page 5, it says this at the top. In the interim, access fees will be negotiated between Tahi and the operators in future years. In the interim, KPMG have calculated a floor and a ceiling, and New South Wales Treasury have recommended assumptions that they will commence at 700 million per annum financial year 21-22 to financial year 23-24. So that probably clarifies the point you were making before. Treasury basically said that that was going to be the policy. Then they increase onwards. Notably, KPMG estimates show that Tahi is non-compliant with the floor test in financial year 2021, subject to IPART determination. What KPMG then goes on to say is that you should be charging these two customers a minimum of $1.4 billion, not $700 million, or a maximum of $4.3 billion. KPMG then goes on to say the introduction of access charges to the public operators is the key reason for the deterioration of estimated budget performance under both Tahi scenarios. You're undercharging your customers, aren't you?
I think that's first to you, Ms. Collin, and then to you, Mr. Krim.
Sorry, I just had a network break for 5 seconds, so I didn't hear Mr. Mookie. I'm really sorry.
Mr. Crimpton, can you answer? You're undercharging your customers by 700 millions a year or 3.5 billion, aren't you?
No, if you look at that report, there are differences between the KPMG calculation and the Treasury calculation as both to what the ROE should be and what rate of return should be. So
indeed. And we will be pursuing that this afternoon. But
Well,
basically,
Mr. Mookie, I don't think Mr. Krim
I'll
had
take the
finished,
point of
so
order.
I think we
Sorry,
let
sorry.
Mr. Krim finish.
I apologise.
So I would suggest you could discuss that with Treasury, because there was a difference of opinion between Treasury and KPMG in relation to the basis of charges in that report.
Treasury have created this policy in order to minimise the impact on state budget, isn't it?
I wouldn't comment on Treasury's intention in terms of creating
But I want
new
to put this to you.
policies.
I want to put this to you. The reason why you are, certainly according to KPMG, undercharging your customers by what could be potentially billions of dollars is because if you charge them the full price, it would destroy the state budget, wouldn't it?
Well, I'm going to take the point of order. Like, these witnesses have come along voluntarily. They are giving evidence as to what they know.
Mr. Khan, I get the thrust of your point of order, and I think it's fairly made. I don't think
I'll move on.
witnesses can give an answer about the overall impact on the state budget.
I'll move on. Ms. Con, we'll conclude with this. You made reference to the 5 agreements or odd that you've entered into, and you helpfully described them in your submission, which I appreciated. Just going to read from, starting from page 10 of your submission. On 2.64, you say that you've entered into a deed with Transport for New South Wales for property development, and this deed deals with the ongoing responsibilities with respect to capital projects which are characterised as either in-flight projects or future. You then go on page 11 to say that you have entered into a corporate services agreement with Transport for New South Wales and Sydney Trains, and that this is for the delivery of corporate services by Transport for New South Wales and Sydney Trains to Tahi. You then go on to say that you've entered into a service agreement between Sydney Trains and New South Wales Trains and detail the arrangements under which Sydney Trains will provide various services to each other, and particularly rolling stock maintenance. So basically, I can infer from this is that your shareholder, well, not your shareholder, but your customers are helping you provide your own corporate services. Transport is helping you to control your property portfolio. As you rightly pointed out, you're not responsible for maintenance. I have the impression that you're not an independent business at all. And in fact, every single policy suite that's been created has been created so the government keeps control of your organisation. Would you like to respond?
Thank you for the question. Yes, I think Tahi has been established to be a state-owned corporation. It has an independent board, as you would know, with a majority of independent directors. It provides a level of independence in terms of the decision making that we have under the regulated assets. As I pointed out in my opening statement, we provide a certain level of assurance on our on the regulated asset base, and we have 3 sources of revenue, which we have discussed at length in the previous hour: revenues from our regulated assets, revenue from our infrastructure asset, and revenue from our property portfolio. The reason I joined Tahi is because I think there is a massive opportunity with a property portfolio which hasn't been unlocked. Those revenues haven't yet been identified in terms of the state of corporate intent, but we will develop additional revenues from this property portfolio, which we will reinvest in the networks. There are opportunities around precincts where we can generate much more revenue that has been done in the past. So to answer your question, I believe we have independence.
Unfortunately,
And that's the reason that I came to
All right, thank you, Ms. Collin. Unfortunately, we have run out of time for this session. Ms. Collin, you have a monumental task in front of you. 1 month into it, we all wish you well. With that, we will have a short break on this hearing and resume at 11 a.m. Right. Well, I'd like to welcome everybody back to this next session of the Public Accountability Committee's review into what is known as TAHI. We have a series of witnesses from Transport for New South Wales. Could I ask each of you to please state your name, your title, and then take either the oath or the affirmation that has been provided to you by the Secretariat. We might adopt the order of you, Ms. Mayers, then Mr. Hardwick, then Mr. Longland.
Thank you, Chair Trudy Mayers. I'll just get the oath up. Thank you. I'm the Deputy Secretary of Corporate Services at Transport for New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God. Thank you.
Thank you, Mr. Chair. John Hardwick. I'm the Executive Director for Asset Management at Transport for New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thanks, Mr. Hardwick. And finally, Mr. Longland.
Good morning, Matt Longland, Chief Executive of Sydney Trains. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you all for your attendance today. There's an opportunity, should you wish to avail it, of making a brief opening statement. Do any of you wish to take that opportunity?
Thank you. Yes, I would appreciate that. Shall I proceed?
Yep, proceed, Ms.
Great. I'd like to thank the committee for the opportunity to provide this opening statement on behalf of Transport. The New South Wales Government is delivering over $72 billion worth of transport projects for the people of New South Wales. This scale of delivery requires contemporary operating models with clear objectives and mandates that ensures customers and communities remain our focus. The establishment of TAHI puts in place new arrangements for transport asset management in New South Wales that reflects modern governance practices. Clear accountabilities and responsibilities across Transport for New South Wales, Sydney Trains, New South Wales Trainlink and TAHI have been established through detailed and extensive collaboration. TAHI has been given a very specific role in the New South Wales rail system. The entity has been established as a strategic asset manager. While Transport is not able to speak to issues relating to TAHI entity classification, accounting standards or fiscal objectives, we can provide strong assurances in regard to safety, operations, asset management and maintenance. Transport remains accountable for the long-term transport strategy, including heavy rail projects. Sydney Trains and New South Wales Trainlink continue as operators of public passenger services. Public transport fares will continue to be set by government and are not and will not be within TAHI's mandate. TAHI will not be an operator or have responsibility for operations of the heavy rail network or services or undertake maintenance. The safety of our rail service has been first and foremost in the development of an operating model with TAHI. Importantly, TAHI's legislative objectives place equal importance on safe and reliable operations as against other objectives. Passenger safety is protected in a range of ways. Sydney Trains continues to take responsibility for safety relating to the core operational assets that it accesses from TAHI to deliver its services. Accordingly, as the accredited rail transport operators under the Rail Safety National Law, Sydney Trains and New South Wales Trainlink make the decisions for all maintenance of railway infrastructure and rolling stock requirements to ensure safety. Transport is obligated to provide TAHI an annual attestation that an asset management plan is in place which ensures the maintenance and safety standards of assets will be maintained. The Office of the National Rail Safety Regulator continues to have oversight of regulatory arrangements for rail assets and has been engaged throughout. Transport has recently been collaborating with the Office of Transport Safety Investigations and providing detail on the safety, asset management and maintenance arrangements implemented between transport rail operators and TAHI. Just finishing off, there are 4 other ways that passenger safety is protected that I would like to highlight. The first of those is that the Transport Secretary not only retains his direction powers over Sydney Trains and New South Wales Trainlink, but also takes a seat on the board of TAHI. This ensures a coordinated approach to safety discussions. The second is the operating licence. That's a significant safety protection. TAHI is required to comply with that licence that's issued by the Minister for Transport and Roads. The third significant safety protection is the Statement of Ministerial Expectations, also issued by the Minister for Transport and Roads. The statement requires that the Tahi Board has assurance that effective safety, environment and asset management is in place, meeting all standards, and annual reporting is provided to the Minister. The fourth significant safety protection is that, like all state-owned corporations, the Portfolio Minister, being the Minister for Transport and Roads, is able to issue a binding direction to the Board to take certain identified action in the public interest, and this is a significant power. In closing, Tahi Transport and the public rail operators have from 1 July 2021 entered into a range of agreements. The agreements support Transport, Tahi, Sydney Trains and New South Wales Trainlink to meet their legislative objectives and obligations and provide a foundation for working together. Transport's strong focus on safety across all parts of transport does not change. Thank you, Chair. Thanks,
Ms. Mayers. Does either of the other two witnesses wish to make any brief opening statement?
Not at this time.
Well, then, this is the one chance, Mr. Longland. So, but I will now hand over to Mr. Mookie to commence the questioning.
Thank you, Chair. And firstly, can I just thank all the witnesses for taking the time to join us this morning. And I just want to start by establishing just some basic information about, well, actually, each of you. Ms. Deputy Secretary, I'll address all questions at you at first instance, as is protocol, if you don't mind, unless you tell me otherwise. Ms. Mayers, how long have you been responsible for Tahi?
Thank you for the question, Mr. Mookie. So I commenced in this role on the 1st of September this year, so a little over a month ago. My role is threefold. I am on the Executive Committee at Transport. My team has been part of the coordination groups from a legal perspective and otherwise in preparing the agreements with Tahi. And thirdly, we service Tahi through a corporate services agreement.
Indeed. Prior to your appointment as, well, Deputy Secretary on, well, was that 1 September?
Yes.
Were you involved in Tahi in any capacity prior to that?
My role prior to that, so I have been with Transport for 5 years. I was heading up the shared services area. So my only interface with Tahi prior would have been in developing the shared services arrangements.
Okay. So but basically you've only been on this role for a month. That's fair?
Yes, that's fair.
And who was the Deputy Secretary responsible for Tahi prior to you?
So in establishing Tahi, the previous Deputy Secretary was Fiona Trussell.
Thank you. And is she with Transport for New South Wales still?
No, she's not, Mr. Mookie.
Okay, thank you. Mr. Longland, how long have you been the CEO of New South Wales of Sydney Trains?
Thank you for the question. I was appointed as the Chief Executive on the 14th of June 2021.
What were you doing prior to that?
Prior to that, I was the Deputy Director General of Transport and Main Roads in Queensland and the Head of Translink, the Public Transport Authority in Queensland.
So this might be an obvious question, but I can only presume that as a Deputy Director in Queensland, you had no involvement with Tahi?
That's correct.
Okay, and Mr. Hardwick, it's good to see you again. I think you have been involved in Tahi prior and longer.
So my role within Transport is we set the asset management framework in accordance with the Treasury asset management policy. And within that framework, I'm accountable to make sure within Transport that we comply with the requirements of that. And so within that, I hold the standard setting for the technical assurance and technical standard setting for all of the assets within the Transport cluster, which includes the heavy rail assets. I'm also accountable for the bringing together of the attestation process and all of the asset management plans and the strategic asset management plans to Treasury and supporting Tahi in that. And I've also been involved in an advisory capacity within a small team where we've been doing work, advising into the group doing the work on Tahi since it's just over 12 months, a bit more than 12 months.
Were you involved with Tahi around 2013 or the inception of the development of it in 2013 or 2014?
I have not been in the transport industry that long. I've only been in the transport industry since 2017.
Well, congratulations on joining, I guess. Look, Ms. Deputy Secretary Mayers, the first set of questions I'd like to ask you are about the genesis of Tahi. But I accept, given that you've only been in the role for a month, you might need to take some of this on notice. So I'll just leave it to you to decide what you are in a position to answer and what you're not in a position to answer. But I will be directing them predominantly at you, because I believe you are the person from Transport who is probably the most appropriate person of the three witnesses that are here. Was creating Tahi Transport's idea?
Thank you for the question, Mr. Mookie. I really couldn't answer that. I would have to take that on notice. I do understand that initial sightings of the Tahi entity were in mid-year budget papers and then raised through budget papers, but yeah, not sure about the idea as such.
Okay. Do you have any does any of the witnesses have any, or perhaps Mr. Hardwick, do you have any idea of whether or not the idea of Tahi originated in the Transport Department?
Thank you for the question. I would not been involved in any of those conversations. My involvement was very much around making sure of the asset management and the maintenance of assets and the safety components of our obligations within Transport and Sydney Trains and New South Wales Trains and Men.
Thank you. Ms. Mayers, when did Transport start work on Tahi?
So my understanding is that when Tahi was announced in 14-15, work commenced with numerous people across Transport and Treasury on the development of the Tahi model.
Is it possible that work started in 2013?
I would have to take that on notice, I'm sorry.
Sure. Was Tahi created as a joint project between Transport and Treasury?
Again, would have to take that question on notice to confirm for you and see what I can provide.
Well, since its inception, was Tahi prior to 1 July 2020 developed jointly by Treasury and Transport?
So there was definitely advisory groups, and Mr. Hardwick may have comments about the member and composition of those, where Transport and Treasury were working collaboratively. Mr. Hardwick?
Yeah, so I have no other, thanks for that, Ms. Mayor. So I have no further information other than obviously the predecessor to Tahi, which was AssetCo, was a Transport idea. So that's the only other information I have related to that. All other items that I know about are related to the asset management and safety obligation.
Ms. Mayers, Treasury officials at Budget Estimates told us that the responsibility for standing up Tahi, I think was how they put it, belonged to the Transport cluster. Do you agree with that?
So Tahi, being a state-owned corporation, is not the responsibility of Transport. Sorry, could you hear me?
Yes, sorry, Ms. Mayers.
Yep. So my understanding is that the establishment of Tahi and the classification is a matter for Treasury.
Indeed.
I might just add to that, Ms. Mayers, if that's okay. It was jointly developed up to July 1, 2020 between Treasury and Transport for New South Wales.
But Treasury left us with the firm impression that you were the driving cluster, not them. Is that true?
I can't comment on that. I do not have that information.
Ms. Mayers, is that true?
Thank you, Mr.
This was only evidence, just to complete, this was only evidence that was given to us like a month ago. And it was pretty clear from the Treasury officials that they had a view that the processes of establishing Tahi operationally belonged to the Transport clusters almost exclusively. Do you agree with them?
Well, I'll take a point of order. What's actually being done here is witnesses are being asked to comment on what really is Mr. Mookie's impression of evidence given at a hearing that these witnesses were not at. Now, that has got to be the height of unfairness. He can put a proposition, but he can't put to agree with his impression.
Oh, I hear the point of order. I think if the question is more grounded in the content of the evidence rather than the impression of the evidence, we might be of assistance.
I'll rephrase it. I'll take Mr. Khan's suggestion. Were you the lead cluster in establishing Tahi?
Thanks, Mr. Mookie. My understanding is that in developing the operating model for Tahi, there was strong collaboration between Treasury and Transport.
Thank you, Ms. Spence. I might at this opportunity table all the Transport documents formally, Mr. Chair, and These have been referred to the witnesses. I hope you have them. Ms. Mears, do you have them?
Thank you. Yes, just opening the document. I received them at 9:30 this morning.
Thank you. Can you tell me what is your understanding of what the objectives were of TAHI at its inception?
Yes, thank you for that question, Mr. Mookie. So, sorry, can you just repeat that again? I was just opening the document.
No problems. What is your understanding of what the objectives of TAHI were at its inception?
Okay, so my understanding is that the Transport Asset Holding Entity was established as a SOC on the 1st of July to assume ownership of RailCorp's asset base, including rail infrastructure, rolling stock stations, facilities, plant equipment and real property.
Okay, and were they the only objectives that you understood?
That would be the key information I have, Mr. Mookie.
Were there any further objectives about its impact on the state's short and medium-term fiscal results you're aware of?
No, I'm unaware of that.
Okay. Can I just take you to, I think, what's labelled Transport Tender 001?
Just that, yes.
You can see that this is a joint briefing to the Minister for Transport and Treasurer in 2014 that's been produced to the Upper House as a result of the call for papers. Can you turn to the first slide, which is page 2?
Yep.
And you can see on the second dot point, it says the intent of this reorganisation is to optimise the management of public transport assets and delivering efficient and effective operations and services by eventually bringing under one controlled entity all of the public transport assets. Does that, broadly speaking, speak to what you just described?
Thanks, Mr. Mookie. A couple of comments. Firstly, that is not the final position on the TAHI establishment. The document, I think you said, was 2014. The other comment I would make is that it is Cabinet in confidence, and on that basis, I can't comment on Cabinet documents.
Look, I accept that, Ms. Mears, but the problem that I've got with that is that you've produced these documents to the Upper House. So I infer, therefore, that Transport has waived it, really, which is the reason why I'm asking you the questions on this. And I accept your point that things may have evolved, but to be clear, I was asking at inception, not now. At inception, the motive for establishing TAHI. So I'll just put it to you again. I understand if you can't answer or want, but I think as a matter of procedural fairness, I should put it to you. Was it the intent of establishing TAHI to optimise the management of public transport assets and delivering efficient and effective operations and services by eventually bringing under one controlled entity all of the public transport assets?
Thank you for the clarification, Mr. Mookie. I would still hold that I can't comment on Cabinet documents. Sure.
Well, I'll just refer you to the next paragraph because I want to be procedurally fair, because I do intend to suggest that the committee make findings on these matters. And says that the other objective, Treasury supports this initiative, but government added a further objective of creating an asset structure that, where feasible, improves the state's short and medium term fiscal results. Do you now accept that one of its objectives when it was created was to improve the state's short and medium term fiscal results?
Thank you, Mr. Mookie. 2 comments, if I could. One is that things have moved on since then, so I would just make that point again, that there's been further advancements on whatever was in that original document, and that I can't comment on Cabinet documents.
Sure. In September 2013, did Transport for New South Wales and New South Wales Treasury agree to fully investigate structural options which facilitate efficient and effective budget and accounting treatment and financial reporting of all public transport asset liabilities and capital expenditure?
Thanks, Mr. Mookie. As you'd appreciate, it's difficult for me to answer that question.
Do you wish to take it on notice?
I can take it on notice and see what I can provide to the committee.
Thank you. Because this document says that in September 2013, Transport for New South Wales and Treasury agreed to fully investigate structural options which facilitate efficient and effective budget and accounting treatment and financial reporting of public transport assets, liabilities and capital expenditure. To be procedurally fair to Transport, I want to put it to you that that's what you agreed to do.
As I mentioned, Mr. Mookie, I will take that on notice and see what can be provided to the committee.
Okay, thank you. I appreciate that, Ms. Meggs. Do you mind turning to what I believe is, sorry, let me just make sure I give you the right reference because I don't want to be rude. I'm fairly positive it's Transport Tender 002.
Mr. Mookie.
Oh, sorry. I'll pause there and allow other members if they wish to ask any questions on that.
Thank you. I just before you leave that last document that we were looking at, which also contains a comparison of the Victorian and Queensland models. In budget estimates, we did hear quite a lot of discussion about how the accounting treatment sort of relies on the treatment of those other entities in Victoria and Queensland. I thought, Mr. Longland, given your background, are you able to tell the committee the sort of major structural difference between the Queensland Rail structure and what has been set up for Tahi?
Thank you for the question. I'm happy to provide some high-level comments from my previous experience in Queensland. So Queensland Rail manage rail assets as commercial assets. They do that through two separate companies, both government-owned. Queensland Rail is a not-for-profit government-owned company that is the deliverer of rail services. So in my previous role in Transport, I was effectively the contract manager, and that part of Queensland Rail was charged with delivering rail services under contract to the department. And then Queensland Rail Limited was the commercial arm that held the assets and drove a return on those assets back to government. So part of my payment to Queensland Rail included an element for return on asset, so to ensure that those assets were treated in a commercial way.
Thank you. Who did Queensland Rail report to?
Queensland Rail had two shareholding ministers, a Minister for Transport and Main Roads and the Treasurer.
Thank you.
Ms. Boyd, could I just add a point, if you wouldn't mind, just that the financial treatment of Tahi, whether comparison to Queensland or Victoria, is a matter for Treasury. Thank you.
Understood. But thank you for your insight, Mr. Longland.
I'd just follow up on that document, just to that. I thought the important point my colleague was making about the question of who added this further objective. As Mr. Mookie's indicated, the document, Transport for New South Wales and Treasury document indicates quite clearly that it was, while Treasury supports this initiative, it was government that added this further objective. Can you shed any further light on that before the committee makes a finding based on the documents that are in front of it? Was it actually government that imposed that added objective about the budget bottom line?
Thank you, Mr. Graham. I have taken that question on notice and I'll do my best to provide what I can to the committee.
Thank you.
Can I just follow that question up? Was it the Expenditure Review Committee of the government? You take that on notice?
Well, I'll take the point of order.
Take that on notice.
It's already been indicated it's taken on notice. Like, you can ask the question in 7 different ways. You're going to get the same answer. She's taken it on notice.
Which I appreciate, Mr. Khan. I was just asking you specifically.
All right. So I think what we might do is we might just return to some ordered questioning. Those matters have been taken on notice, and I might actually go to you, Mr. Mookie, to take this forward at this point.
Thank you. Can I turn to tender document 002, if you don't mind.
Mr. Mookie, would you just mind confirming the title of that one?
Yeah, it's called Transport Tender. Transport _tender _002.
Yes. Okay. Thank you.
Thank you. Transport for New South Wales, in a joint submission with Treasury, propose the establishment of TAHI because by holding public transport assets in an independent commercial entity, these expenses can be reclassified in the budget as a capital investment.
Thank you for the question, Mr. Mookie. A couple of points. The first one is that any accounting or financial matters are relevant to be referred to Treasury. The other is that this document, Transport Tender 002, that you've referred me to is also a Cabinet submission, Cabinet in confidence. So I would be taking the position that I can't comment on Cabinet documents.
True, Mr. Minister, I wasn't asking you to comment on Cabinet documents. I was asking you whether or not Transport recommended the establishment in a joint submission with Treasury, the establishment of TAHI because it would allow the assets to be held in an independent commercial entity, and these expenses can be reclassified in the budget as a capital investment.
If you're not referring to the document, then I am not aware of that, and I can't comment on a Cabinet document.
Sure. Look, I appreciate that, Ms. Mez. But I do think as a matter of procedural fairness, given that, again, I'm going to suggest the committee make findings on the basis of these documents, that I should put them to you, at least as a matter of procedural fairness, for you to answer them however you see fit.
Yes, thanks. I appreciate that, Mr. Mookie. I understand.
This is a Cabinet submission that is in the name of the Honourable Andrew Constance MP and the Minister for who was the Minister for Transport and Infrastructure, and the Honourable Gladys Berejiklian, who was the Treasurer. And it says on page 3, proposal, the very first reason it gives for the establishment of TAHI is this: grants currently paid to Railcorp and other agencies for investment in public transport infrastructure have in the past appeared on the budget as an expense. By holding public transport assets in an independent commercial entity, these expenses can be reclassified in the budget as a capital investment. I want to put it to you and the transport cluster that the main reason why TAHI was established was because to convert costs that otherwise appear in the budget as an expense to costs that would appear as a capital investment, and that would affect the budget result. I will put this question to Treasury as well, but I'm putting it to you first.
Thank you. I appreciate that and understand that you're putting these to me. The financial treatments and the accounting treatments are a matter for Treasury, so I couldn't comment on those. I would also make the same comment that I cannot comment on Cabinet documents. Thank you, Mr. Mookie.
Mr. Mookie, I was asking a question here.
Yes, please, if you wish to follow up.
If you're not able to satisfy the committee that was the purpose, from a transport agency's perspective, what other possible purpose is there for the creation of this entity?
Thank you, Mr. Shoebridge. I can't talk to 2014, but what I can say is that in the establishment of the entity, there were some joint outcomes that would be, as the strategic asset owner, would really maximise the commercial opportunities of the assets while retaining safety and maintenance within transport itself. So
that's no benefit to you. What you're suggesting there is that TAHI may be able to leverage its $11 billion worth of property assets and become a property developer as well as a rail infrastructure owner. But that's no benefit to Transport for New South Wales, is it?
Thank you, Mr. Shoebridge. I wasn't suggesting they were a developer. I was suggesting as a strategic asset owner, they could optimise the assets for the state. But there are other benefits to transport, and they are really around a third line of assurance that they offer in the safety space. They have some role to play in there. Mr. Hardwick may wish to comment. That certainly provides some value to transport in addition to the other items we mentioned.
We will get to safety later.
On the safety point, Transport for New South Wales identified right at the outset that there was a high risk by separating the ownership in this way, a high risk of safety risks in the creation of this structure. Far from being a positive, that was identified as a high risk at the outset, wasn't it?
Thank you for that question, Mr. Shoebridge. And I believe the Secretary for Transport commented on this in estimates, also saying that we used a range of advice and identified issues and risks that should be addressed in the creation of the Tahi operating model, and we're confident that they have been addressed and dealt with through the establishment of it. Mr. Hardwick, did you have any comments?
No, Ms. Mayers, just stopping you there. You have identified risk, you have identified safety as a positive in your initial answer. In your further answer, you then said, oh, actually, yes, there was a risk, and we've now mitigated that risk, and we're mitigating that risk. So we can reject, whether or not that's fully mitigated is a matter we may well explore. So we can reject safety as a rationale. You say that you can't comment on the budget benefits as a rationale. So we're left with no compelling rationale from your agency about why on earth this entity was created, aren't we?
I'm going to take a point of order. And actually, it's on two bases. The first is that the witness was seeking to answer by referring part of her response to Mr. Hardwick, and she should be allowed to do that. The second thing is, Chair, that actually at this stage, neither you nor Mr. Mookie can speak for what conclusions this committee will come to. We are entitled to hear all the evidence and consider it at the end. And so I think it is unfair to put a proposition to a witness that this committee has already come to a conclusion on a particular matter in the question or speech that you give. So I ask that you put it in a proper form, but I also ask that the witness be entitled to answer the question before you ask another question.
Well, Ms. Khan, I put no such conclusion, and I don't have a firm view myself about the conclusion. My proposition was based upon the absence of a compelling or even an identified reason coming from Transport for New South Wales. So, Ms. Mayers, I'd ask if you could answer the question, and of course you may refer to Mr. Hardwick or Mr. Longland to provide further assistance.
So,
can you just, sorry, Mr. Shoebridge, can you just clarify the question you would like answered again for the record?
You say that the budget basis, you can't put that forward as a rationale for Tahi. You then initially said, well, there was a safety rationale for it. And then when you clarified your evidence, you said, well, actually, there's a safety risk that you think has been mitigated. So if it's not for safety, and if it's not for a budget purpose, what on earth other purpose that benefits Transport for New South Wales explains the creation of this entity?
Thanks, Mr. Shoebridge. Just a point of clarification. You asked what benefit there was of Tahi to Transport, and that was the response I gave around the assurance of safety. Also, in noting that I can't currently answer to previous documents or works in 2013 or 14, I did agree to take those questions on notice and see what can be provided to the committee as further evidence. I will refer to Mr. Hardwick to see if there's any further points that would be relevant to the committee.
thanks, Ms. Mayers. Yeah, I've got just a couple of points, and I think really importantly, safety does remain our number one priority across transport. It is enshrined in the Act. It is supported by the Rail Safety National Law. The operators maintain their safety accreditation, and decisions about the assets remain the maintenance and delivery and subject of the same safety assurance regimes that existed prior to July 1. A couple of the things which I think Ms. Mayers was trying to elaborate on, was the establishment of Tahi has added a third line of assurance through the independent board and CEO to critically assess the risk exposures that are appropriately controlled by Transport for New South Wales, Sydney Trains and New South Wales Trains and private operators that are complying with their safety legislation obligations to operate a safe and reliable network.
Thank you, Chair. Do you mind?
This is the board, Mr. Hardwick, that the New South Wales budget, the New South Wales Cabinet submission says is going to be deliberately dumbed down and have no expertise and be basically populated by lawyers and low-profile persons. Is that the board that you're saying will provide an additional level of assurance?
That's outrageous. There's nothing wrong with lawyers.
Well, I think Mr. Hardwick may answer the question.
Thank you for that question. I can't comment on the government's position on these matters, but what I can say is the interactions I've had, where I've had to submit things to the current board of Tahi, they've discharged those accountabilities as the way I'd expect for any board that I've reported into for safety and asset management matters. And they actually, the questioning and the way in which they are discharging their accountabilities related to safety and asset management are exemplary of people that have actually been involved in highly critical assets in the past in their careers.
You would be aware, wouldn't you, Mr. Hardwick, of the Cabinet submission that says the intent of the government is to not have people with infrastructure and railway skills on the board, but indeed to have no low-profile persons, lawyers and the like, who therefore won't be able to assert the kind of independence and quality assurance you're putting forward as a benefit, Mr. Hardwick. You'd be aware of that, wouldn't you?
Mr. Shorebridge, thank you for the question. I can't comment on what the government has done, but I can comment on the interactions I've had with the board. And those board members are highly skilled in their capabilities related to assurance and their WHS obligations as board members, and the critical infrastructure of their backgrounds suggests to me that they have the capability to discharge those accountabilities with respect to the rail asset.
Or this may be addressed further. Ms. Boyd, did you have anything on this? Or?
Thank you, Chair. Just coming back to your response, Ms. Mayers, in relation to sort of the rationale and the benefits that Tahi could possibly have in this situation. You mentioned the ability to, I guess, make more profit out of the assets. Is that necessarily, I guess, likely, given that you've got 90% of those assets being leased out to the government? Can you explain that?
Thank you, Ms. Boyd, for that question. I think the way that the assets are commercially managed is a matter for Tahi, so I couldn't comment on that. But what I would say is that in setting up of Tahi, I know that one of the outcomes that was looking to be achieved, balanced off against safety, community outcomes, and a range of others that I can find and read out if it serves the committee, was that there was a commercial return. So there is some optimisation and more strategic management of the assets intended as part of the current model. I'm not speaking to any documents from the past, but as to the current model.
By setting up this quite complicated model, which, and I know you can't comment on this, does appear to be primarily for accounting reasons and to make the budget look better, but let's put that to one side. Haven't we created additional costs? We've got the costs of the board, which we've heard, are quite, in terms of salary, is quite high, but also the costs of the model in terms of the interactions and the legal structure and everything else that needs to be set up to make it work between Tahi and Sydney Trains. Aren't we creating actual additional real costs?
Thanks, Ms. Boyd. So what I would say is that, yes, there are agreements set up between Tahi and Transport. There are interfaces that we have set up with them. Obviously, I can't comment on Tahi costs specifically, or their board, or other costs that you mentioned. I haven't got a comparison financially of the difference between Railcorp versus Tahi and what those internal costs may be. I don't believe we've put any new resources on for Tahi from a transport perspective. So without that information in front of me, I would just say, yes, there are interfaces set up, but we're doing those within our current business.
Just one final question from me. What's the benefit to the people of New South Wales? What's the benefit to passengers of Tahi?
Mr. Longland or Mr. Hardwick may wish to answer this. I think there's a few that are set out in the current model. Certainly two that we've spoken of are the additional layer of assurance around safety, so safety of services, and also the commercial outcomes that may see benefit to the people of New South Wales.
Sorry, you've mentioned safety again. What do you mean by that? How is there another layer of assurance? Are you saying that Tahi has expertise in maintenance or safety? Is there a...
not maintenance, to be clear, but I'll let Mr. Hardwick speak to that, and Mr. Longland may have a comment too.
Thank you.
Thank you for that question. I think the key for me in the safety space is around the establishment of the third line of assurance from the asset owner with that true independence from the activities of the day-to-day activities of the business. And it's really given us an ability to look at the risk exposures from that independent view. And they are reviewing the work that I do and the work of Sydney Trains, New South Wales Trains and the private operators through that independent lens, which gives you a higher level of confidence that the things that are being done within transport and the operators and maintainers has that due diligence piece put across it.
How does this differ, Mr. Hardwick, from the 1996 structure that resulted in such disaster and safety issues?
So I can't comment around, thank you for the question, Ms. Boyd. I can't comment around the items of 1996, but the things that have been put in place since 1996 are the things like the Rail Safety National Law, the ONSA and their responsibilities and the way in which they discharge it. We have also implemented a number of ways in which that occurs, and obviously the rail transport operators themselves holding that true accountability for the fully assured delivery of services and outcomes at that operational level is really important, and maybe Mr. Longman would like to add some more to that.
Thank you, Mr. Hardwick. Just to reinforce Mr. Hardwick's comment that the creation of TAHI has no impact on the operational rail safety risks. Day-to-day safety management of rail and rail service delivery remains with the operators and with Transport for New South Wales. In Sydney Trains, from our perspective and the agency that I lead, we are the agency that is accredited under Rail Safety National Law as a rolling stock operator and a rail infrastructure manager. We have defined systems in place with our safety management system. We have an asset management process that is internationally accredited, and that we work with Mr. Hardwick and Transport on the development of asset management plans. They're funded and we undertake that maintenance.
So just to clarify, Mr. Longland, you're saying that it has no impact on the safety. Ms. Mares is saying that it's beneficial for the safety of the network. Which is it?
What I could say, Ms. Boyd, thank you for the follow-up, is that the creation of TAHI has no adverse impact on the operational rail safety.
Thank you. Back to you, Chair.
Thanks, Ms. Boyd. Mr. Hardwick, do I understand your evidence to be that the establishment of this independent TAHI board is another level of assurance in the system? Is that your evidence?
It's the third line of assurance as the asset owner with an independent board. That's the way in which it's managing its safety obligations. Any board, state-owned corporation board or any other board has an obligation to discharge its WHS obligations.
Mr. Hardwick, in fairness to you, I will read you paragraph 5.10 from the submission that went to Cabinet to establish this entity. And I'll ask you if, having heard that, you stand by that position. It reads, ultimately, the risk that the board wishes to replace the government's investment priorities with its own depends on the nature of the persons appointed as board members. It is not proposed that the TAHI board would consist of high-profile persons with infrastructure planning backgrounds, but rather expert financiers, asset managers, and or lawyers. Having heard that, do you stand by your evidence that there's a third level of assurance?
So thank you for that question. I can't comment on that document you're reading from, as it's a Cabinet in confidence document. But what I can say in general terms, that the board, and my interactions and experience with the board, is that their inquiry and the way in which they have set up the assurance frameworks for TAHI and the way in which it interacts with Transport for New South Wales will be the types of things I'd expect for a board that I report into.
I'll hand over to Mr. Mulkey.
Thank you. I'm just through, with your permission, Ms. Mares, I think these questions are best directed to Mr. Longford, if that's possible.
Longland? Yep.
Longford. To be fair, I do apologise. I often call out transport officials for mispronouncing my name, so I really do apologise to you, Mr. Longland.
Have I got it right, Mr. Mulkey?
You have done very well, Ms. Mares. I believe you are the first Transport Deputy Secretary I've ever questioned that has got it right at first instance. So congratulations. We'll make a finding about that. Can I, Mr. Longland, prior to the establishment of TAHI, did Sydney Trains and or New South Wales Trains pay anything to use Railcorp's assets?
Thank you for the question, Mr. Mookie, and no offence taken on the pronunciation of my name. My understanding, whilst I wasn't part of Sydney Trains prior to the establishment of Tahi, was that there was not any access fees paid.
But prior to the establishment of Sydney Trains, there was no access fee had to be budgeted for in the Sydney Trains budget in order to access the rail network.
Sorry, just to clarify your question, you said prior to the establishment of Sydney Trains, did you mean prior to the establishment of Tahi?
Prior to the establishment of Tahi.
That's correct.
Thank you. Was it the case that in order to allow your organisation and New South Wales Trains to pay a commercial rate of return to Tahi, the budget was needed to provide your organisation and your counterparty an additional $800 million per year?
Thank you for the question. In terms of the details about payments that are made, they're matters that I would need to take on notice if you're after individual figures in terms of annual access fees. What I can say is that Sydney Trains payments to Tahi for access and licence fees are managed through our existing and normal budget processes with Transport for New South Wales each year.
This year, did you receive an additional $800 million in the budget to pay Tahi? Sorry, I should just reclassify it. Did you receive up to $800 million to pay Tahi, shared with New South Wales Trains?
Thank you for the question, Mr. Mookie. Sydney Trains did receive an allocation within our annual budget for the payment of access fees for Tahi, yes.
How much was that?
Thank you for the follow-up. As I stated earlier, I would need to take that question on notice if you're after a specific figure.
Do you have an estimate range?
I wouldn't want to speculate.
Well, to be fair, I'm not asking you to speculate, Mr. Longland, because you are the CEO. I believe you would know. It's a pretty large part of your budget.
Well, I'll take the point.
Okay,
I'll take the notice.
Well, no, I hear the point of order, because I think, Mr. Khan, if we're talking about a potential budget item in the order of $800 million, I think it's fair to assume that the CEO would have some understanding of the nature of that, and it's fair to explore, but to allow the exploration to be limited.
Well, you said you would hear more from me.
I will.
It is the standard practice, and indeed it's quite clear from the rules of procedural fairness adopted by this committee that a witness is entitled to take a question on notice. What is now being embarked upon is an invitation to guess. So he, having said he will take it on notice as provided in the rules of procedural fairness, which you say this committee proceeds by, then that's the end of the matter.
Well, I agree with you so far as a witness is entitled to take a question on notice, and indeed to persist on wishing to take a question on notice. But it is open to a committee member to explore a matter, and I will allow some leniency to Mr. Mookie to explore the matter. But that's the decision I'll come to.
Mr. Longland, as it is a significant amount of public money we are talking about, can you shed any light on what the additional appropriation that was given to Sydney Trains this year in order to pay Tahi's rail access fee?
Thank you for the question, Mr. Mookie. I'll go back to my previous response, that in order to provide you with the answer on the access fee paid to Tahi in financial year 2021-22, I would need to take that question on notice.
Okay, I appreciate that, Mr. I won't push it any further. Can I just refer you to also Transport Tender Document 002? And I'll just read the relevant section to you in the order of speed. This is from the Cabinet submission. It says this: Sydney Trains and New South Wales Trains do not currently pay anything for use of the assets. To allow them to pay a commercial rate to Tahi, the budget will need to provide an additional $800 million per annum of funding to the public transport operators. In turn, it is intended that Tahi should return the majority of this $800 million per annum to the government as dividends, producing no material effect on the budget from this injection of money. It goes on to say this: in addition, equity injections will be provided directly from the New South Wales government to the Tahi for capital works. These monies will no longer appear in the budget as capital expenses, improving the budget position. That, to the best of your knowledge, was reflected in this year's budget, was it not?
Mr. Mookie, to go back to Ms. Mayor's earlier response on the question of this very same cabinet submission, my response is similar, that I am unable to comment on the detail of a cabinet submission.
Okay, I won't press it, Mr. Longland. I think I put it to you reasonably fairly to allow you that opportunity, so I will move on. And can I say how much you are budgeting? You budget over a what? 2-year cycle, 3-year cycle, 4-year cycle, 5-year cycle? We
budget over a 4-year forward estimate period.
Great. So you would be currently in the process or have started to budget for 23-24, correct?
That's correct.
And are you up to 24-25?
Look, the budget process is ongoing. We have a 10-year asset management plan. So okay. Given the long life of rail assets, we often plan quite a long way out, correct?
And what do you expect to pay Tahi to access their assets in 23-24?
I would need to take that question on notice, but what I can say in terms of the forward calculation of access fees, they are really governed by the valuation of the asset and also any new assets that are delivered over that period. So the numbers would change year on year, depending on those variables.
Yeah. Mr. Mookie, would you mind if I just add a point on that also? Thank you. So with regard to the setting of future fees, just a couple of pieces of information that I think are useful to the committee. One is that in setting the fees, they must align, Tahi must align them to the rail access undertaking, and there is an annual true-up. So there will be a true-up of those fees, and that will then affect the future fees and the reforecasting. So there is that annual process that would happen in line with the budgeting process Mr. Longland mentioned.
I appreciate that, Ms. Mayers, but I'm asking these questions of Mr. Longland because he is the principal customer of Tahi, it seems.
Thank you.
And what happens in terms of your budget if the rail access fees you have to pay rise significantly above $800 million?
Thank you for the question. In terms of the rail access fees and the future rail access fees that are payable and the impact on the Sydney Trains budget, as I said, those fees are incorporated in our annual budget build. We work closely with Transport for New South Wales, and we manage the payment of those fees through our normal budget process.
Thank you. Chair, I am just going to pause here to see if there's any other members. Otherwise, I do propose to start talking about another document, if that's okay.
All right. Ms. Boyd, do you have anything on this? Mr. Graham?
Thank you, Chair. I just wanted to return, this follows from the point Mr. Mookie was just making about the cost pressures. Ms. Mayers, in your opening statement, you said the public fares are not within...
Sorry, Mr. Graham, would you just mind starting again? You were a bit muffled on my audio.
In your opening statement, you said this: public transport fares are not within Tahi's remit, which is accurate. However, the cost base for the provision of public transport is. When Tahi appeared this morning, they were very clear about what their objectives were, and that's to maximise the value of the transport assets. That is, maximise their commercial returns. Aren't those two things going to come in conflict over time? Isn't that going to put pressure on the cost base of public transport and therefore on public transport fares over time?
Thank you for that question, Mr. Graham. As you would appreciate, the fare setting is highly regulated. It's a matter for government, which is also managed through IPART, and really any fare setting would be set at that level.
But the costs will be relevant to those considerations, won't they?
So I'd reiterate my opening statement that fares are not a part of Tahi's mandate at all, and nor will they be, and that fare setting is a highly regulated part of a government decision.
Thank you.
Chair.
Well, sorry, there's one question that flows from that. Ms. Mayers, you understand that Tahi will be an independent board, correct?
Yes.
You understand that their primary objective is to maximise the return on their assets?
It's one of the objectives that is set out to them.
Well, if they wish to maximise their return on their assets, there's a very real risk to Transport and for Sydney Trains that they will substantially increase the access fee. That would be one of the obvious ways to increase the return on their assets, correct?
As I said, there is certain financial principles and pricing principles that must be set in setting their access fees. They are a matter for Tahi, but they do need to align to the rail access undertaking. I don't know if they reference the building blocks, but there is pretty standard practice put in place, is my understanding, around the setting of access fees. So that would be done that they would set the access fees, and then there's obviously ongoing negotiations that we would have with them.
Ms. Mayers, Tahi told us this morning that they're in the middle of reviewing their access fees. They've got consultants in the field. They're doing this. There's no set of standard procedures in place. They're in the process of working it out right now, aren't they?
So I can't comment on what Tahi is undertaking at the moment, but I can say that under agreements with them, they must align to the rail access undertaking. I can also share with the committee that the rail access undertaking is currently with IPART for review.
Ultimately, it's a simple proposition, Ms. Mayers, and I wonder if you will accept it or reject it. There is a very substantial risk that to maximise their return, they will increase the fees. Those fees have to be paid from somewhere, and the likelihood, isn't it, that if the fees go up, it'll end up being paid in part by increased ticket prices from the general public. That's a pretty much, you would agree with that basic proposition, wouldn't you, Ms. Mayers?
Thanks for that proposition, Mr. Shoebridge. What I would say is that Tahi do have an approach for setting of fees, and I'd reiterate my earlier comments that they have to be in line with agreements that we have made with them, that they are reviewable, and that we would be negotiating those with them.
They've got the whip hand, aren't they? Don't they, though? Because they've got the only set of tracks for you to use. They've got the whip hand. It's not like you can go somewhere else.
Well, I guess the comment I would make on that is that ultimately, you know, a SOC is a government-controlled entity.
Mr. Mayers, Transport collaborated with Treasury, did it not, to model what the access fees would be?
Sorry, can you repeat that? Transport
collaborated with Treasury to jointly determine the operating model that would set the access fees, correct?
The operating model. Yes, I believe there was a lot of collaboration between Treasury and Transport. And
Transport and Treasury began to conflict about certain assumptions of that model. Is that correct?
I'm unaware of conflict between Treasury and Transport. I know that they work together on it.
Okay. Yeah. In order to develop its own position, did Transport approach KPMG to assist them with creating a long-term operating model assessment?
Thank you for that question, Mr. Mookie. Yes, Transport commissioned KPMG to support the development of the operating model and make sure it met statutory requirements. Just of note, that was not, safety was not in the remit of KPMG for that particular report, but it did help define how Tahi, Transport and the operators will perform their functions and duties. And it was a really important input to the government in assessment of risks across the operating model.
Thank you, Ms. Mason. That's really helpful. Look, to be fair, I'm not inferring that KPMG did have remit over safety, just to be clear. So I appreciate that. But in the process of creating that report, there was extensive collaboration between Treasury and Transport, you would agree?
That is my understanding, though you can appreciate I wasn't involved in it personally.
Sure. And that included multiple interviews with Transport for New South Wales staff, correct?
I could not answer that one way or another, Mr. Mookie.
Well, Mr. Hardwick, I think, might be in a position. You were consulted, weren't you, in the production of this report extensively?
Thank you for the question, Mr. Mookie. Yes, I was involved in an advisory capacity, and the work that myself and a small team were doing on the safety and asset management pieces were inputs to multiple pieces of work at that time that were going on.
At least 15 to 20 to 25 transport staff were involved. That's correct?
Thank you for the question. I couldn't comment exactly what the number was, Mr. Mookie, but there were a few people involved.
That's not unreasonable for us to infer. The consultation was extensive, correct?
So to answer your question, there was consultation and advisory groups set up to give input to some of the questions we were asked.
Ms. Mayors, Treasury were extensively involved in this as well, weren't they? With Transport's blessing.
I'm unsure if Treasury were extensively involved in the advisory groups. I don't know if Mr. Hardwick's got a comment on that, but I know that we collaborated with Treasury.
Thank you, Ms. Mayors. In the areas that I was involved in, Treasury were not a key player in the safety and asset management advisory areas, so I can't comment on the other areas.
But to be fair, Mr. Hardwick, as Mr. Mayors just said, this had nothing to do with safety. So I'll put that aside. I might ask you, Ms. Mayors, to take this on notice if you can. Did Transport consent to upwards of 10 to 20 specific document changes by Treasury to this document? If you can take that on notice, that would be helpful.
Thanks, Mr. Mookie. Happy to take that question on notice and see what we can provide to you.
Thank you. By the way, I couldn't see where Transport had disclosed its decision to hire KPMG on the contract database. Can you on notice provide us where you publicly disclosed this?
Yeah, my understanding is it is disclosed, so we will definitely take that on notice and follow up.
Thank you. How much did you pay them?
So let me just grab that for you. I do have that available. So the KPMG report which I've run through the implementation of Tahi. So the KPMG cost was around $1 million.
Thank you. And if you'll notice as well, can you tell us how they were selected?
I understand it was in line with procurement procedures.
Ms. Mayors, I'd be shocked if you said that they was not in line with procurement procedures. So if you don't mind just telling me what specific procurement method was followed, that would be most helpful, given it's $1 million.
Thank you for the clarification. We'll take that on notice and see what we can provide.
Indeed. Did this report find that the fees that were payable according to the IPART determination was circa 700 million to 3.5 billion more than what Treasury expected?
Thank you for that question, Mr. Mookie. I have to say that I have not read the report, so I couldn't comment on what is within it.
So can I now take you to tender document, Transport Tender Document 003?
Yep.
Which is the report.
Yep.
And I'm just going to read to you the same section that I read to Tahi, in which it says, and I'm reading from Roman numeral page 5, access fees will be negotiated between Tahi and the operators in future years. In the interim, KPMG have calculated a floor and ceiling, and New South Wales Treasury have recommended an assumption that will commence at $700 million per annum for FY 21-22 to 22-24, then increase onwards. Notably, KPMG estimates show that Tahi is non-compliant with the floor test in FY21 subject to IPART determination. They then go on to say that the minimum that Tahi should be charging New South Wales Trains and Sydney Trains is about 1.4 billion, and the maximum is 4.34 billion. And they go, the introduction of access charges to the public operators is the key reason for deterioration of estimated budget performance under both Tahi scenarios. Now, I just want to put to you that when Transport saw that, Transport was alarmed. Is that correct?
Thanks, Mr. Mookie. I cannot comment. No one has said to me they were alarmed.
Did this create massive consternation inside the Transport cluster?
Not that I'm aware of, Mr. Mookie.
Did this cause a conflict between Transport and Treasury?
Again, difficult for me to respond considering my tenure in this role, however, not that I am aware of.
Did Treasury strongly object to this report?
Oh, okay, that's a matter for Treasury, Mr. Mookie.
Did Treasury ever communicate to Transport that they would withdraw their cooperation with this process as a result of the vehemence of their disagreement with its findings?
I'm unaware of any such correspondence.
Yes, I accept that you are unaware, Ms. Mayers, but is Mr. Hardwick or anyone else able to shed any light on this?
And I also think if you're asking what Treasury sent, that's a matter for Treasury, Mr.
No,
Mookie.
I'm asking what Transport received. And
I'm unaware.
can you take it on notice?
I'll take on notice if Transport, can you just clarify what we're taking on notice, Mr. Mookie?
Did Treasury ever communicate in either writing or verbally to anyone from Transport that they would withdraw their cooperation from this process as a result of the vehemence of their disagreement with its findings?
Thank you for the clarification. I'll take that on notice.
Thank you. Did Treasury then indicate to Transport that as a result of what they considered to be Transport exceeding its authority, they would be producing separate advice for Cabinet?
Again, unaware of any such engagement or interaction.
Did Treasury ever ask Transport to participate in any report that they were producing with KPMG that would contradict this report?
I don't know offhand if that has happened either, Mr. Mookie.
Did Treasury ever provide you a copy, Transport a copy, of a report produced by Ms. Heather Watson of KPMG?
I would have to take that on notice.
Did anybody from the Transport cluster ever make contact with anybody from KPMG to ask why that firm was providing competing advice?
Thanks, Mr. Mookie. I'm unaware of that. Whether that occurred, I would have to take it on notice.
After we've established through estimates, and look, I don't want to breach Mr. Khan's observation here, so I will reference what I'm talking to you and put a proposition to you, so it's not my inference. But the Treasury Secretary has accepted that there was a dispute with the Transport Secretary. Are you aware of that?
No, I am not aware it was accepted that there was a dispute.
Okay, it's been publicly reported multiple times as well. The Treasury Secretary and the Secretary of Premier and Cabinet have both separately confirmed that a meeting was held between the then Secretary of Transport, the Treasury, and the Secretary of DP&C to resolve the differences between Treasury and Transport. Can you shed any particular light on what Transport's objections were that led to such a meeting?
Mr. Mookie, what I would comment, which is probably aligned with the Secretary of Transport's comments in estimates, is that we weren't party to those conversations, but we're aware there were ongoing discussions between those parties to come to the final model.
When you say we, are you specifically referring to yourself and Mr. Sharp?
Transport generally, and Mr. Sharp's comments in estimates also, Mr. Mookie.
Just, Ms. Mayers, can I invite you to clarify that, please? Are you saying that Transport had no involvement in a meeting that was attended by the Transport Secretary at the time?
Thank you for your clarification. No, I'm obviously saying I am not aware of that meeting, but I'm acknowledging that there would have been interactions between those parties.
Okay, so can you take on notice and provide us whatever information Transport has within its possession as to what the agenda of that meeting was, when that meeting took place, and what the outcome was?
Noted. I'll take that on notice, Mr. Mookie.
Thank you. I just want to ask you finally on this matter. After Transport received a warning that the Treasury assumptions that led to the decision to commence with a $700 million rail access fee was wrong, to the tune of what could be $700 million or $3.5 billion. What did Transport do?
Mr. Mookie, you're referring to the KPMG document that you referenced earlier in that statement?
Yes. What did you do after you received this document?
Right. So what I can't comment on financial treatments. What I can say is that it did inform significantly the agreements that we've now put in place with Tahi, including the track access agreements. So it was a useful document in determining how we might move forward with the operating model, how the agreements would be set up and put in place was a key input.
Mr. Longland, has anyone ever told you that you might be undercharged to the tune of $700 million to $3.5 billion in order to access Tahi's assets?
Thank you for the question, Mr. Mookie. No, that's not been a part of any briefing that I've received since arriving at Sydney Trains.
Has your organisation ever undertook its own assessment of what the result of the IPART methodology would be independently of Transport and Treasury?
No, those assessments were undertaken within Transport for New South Wales.
Why not?
Transport for New South Wales are our funder. So each year we work on a budget cycle with Transport and we manage access fees as part of that budget.
And IPART will complete their first assessment of this in October 22, is that correct?
I'm not aware of that date.
Ms. Mayor, are you aware of that date?
Are you talking about the Tahi methodology or the rail access undertaking, Mr. Mookie?
I think I'm specifically referring to the first compliance undertaking by IPART into the rail access undertaking.
My understanding, and I perhaps will take this on notice just to make sure that I'm giving you the right factual information, is that that review commenced in April 21. So I would expect it to be finalised April 22, but I'll take it on notice to clarify that.
Could you, because Treasury in response to budget estimates, and again, I don't want to breach Mr. Khan's rule here, but I just want to give you the factual information that I'm aware of. They say that it will be completed in October 2022, and that's the answer they gave us on notice.
Okay. Let me clarify that, Mr. Mookie.
Yeah, thank you. Mr. Chair, I'm just going to invite any questions on this matter from any other committee members before I go to the last matter that I have.
Well, I haven't seen any other member indicate at this stage, Mr. Mookie, so I'll leave the call with you.
Ms. Mayers, was Transport late in establishing Tahi?
Apologies, could you repeat that?
Was Transport late in establishing Tahi?
So Transport did not establish Tahi. Tahi as a SOC was established by Treasury and Government.
Okay. Well, given that I think Mr. Hardwick made clear that Treasury or Transport was involved in the establishment of Asset Co, I think as you put it, did the establishment of Tahi meet the times frame that was set out by Transport and Treasury in the advice that they provided to the Cabinet?
So my understanding is that there was agreement, there was agreement to move the establishment date.
Indeed. So can I just take you back to tender document 002, page 13, which says the Transport Asset Holding Entity Transition Plan, which says, look, I could take you through it all, but I'll just get to the key point, which is point 5. By 1 July 2019, have transferred remaining public transport assets, i.e. buses, PTAHC, I don't know what that means, tranche 3, and fully operational from this date. Meaning Tahi was meant to be fully operational from 2019, correct?
That's my understanding, yes.
And that was in order to satisfy the undertakings that were provided by someone in the government to the ABS, correct?
I can't comment on whether it was to satisfy anything for the ABS. I can say that that in working with implementing the model, key stakeholders were consulted and the relevant approvals given to extend that timeline.
When was the decision made to extend the timeline?
I don't have that at hand. I would have to take that on notice, Mr. Mookie.
Could you? Who made the decision to extend the timeline?
Also take that on notice.
Did that follow advice by Transport?
I believe, let me just see if I've got any info for you on that. If you could give me a moment. Yeah, I'm sorry, I don't have that information. I'll take that on notice.
Was it your understanding that it was Treasury's responsibility to communicate this to the ABS?
As previously stated, I'll take that on notice.
Did Treasury ever express at any point alarm to anyone in Transport that the establishment of Tahi was running late, and as a result, there was a risk of breaching the undertakings to the ABS?
I'm not aware of that.
Will you take that on notice?
I will take it on notice, Mr. Mookie.
Did anyone at any point from Treasury ever say to anyone from Transport that if Tahi was failed to establish on time in accordance with the undertakings provided to the ABS, that there was a real risk of reclassification of Tahi and its return to the general government sector, which would cost the budget billions?
Again, I couldn't answer that. Or I can say that matters of classification of Tahi are obviously for Treasury and the ABS, but in response to that question in particular, I can take on notice and see if I can find if anyone has got any information on that that would be relevant.
Can I just put this to you? Just so I can be a bit more direct, which might assist. Was there ever a Mr. Peter Perdiccas involved in the establishment of Tahi?
Yes.
Was he liaising with Treasury?
There was collaboration across Transport and Treasury with multiple people, and Mr. Perdiccas was no doubt in discussions with them.
Was he perhaps a person who, did he ever create any internal warnings inside Transport that there was a risk of a breach of the ABS undertakings?
So I'm not aware of that, and I couldn't comment for Mr. Perdiccas.
Sure, but I'm asking you to comment more from a leadership perspective. Did the leadership team of Transport ever receive a warning from Mr. Perdiccas or anyone else that Treasury had raised alarms that as a result of Transport's failures, there was likely risk of breaching undertakings made to ABS?
Thank you for that clarification. I believe I've taken that on notice to see what I can find for the committee.
I am just, you have, but I'm asking you very specifically now, was the leadership team ever warned by anyone inside Transport that Treasury had raised a concern that as a result of Transport's failures, there was a risk of breaching ABS undertakings?
So I do not know the answer to that question, Mr. Mookie. I do not know if that occurred.
Okay, Mr. Chair, I'm conscious that we have 1 minute left. I will stop there and allow any other committee members, because I'm very eager to keep to Mr. Carr's time.
That's kind. That's kind.
I think that's probably timely we finish at this point. And whilst we are on the public feed, I thought it might be, I'm going to first of all thank the witnesses for their attendance, and I think that concludes the questions that have been directed to you. I do thank you for your assistance, and I note that a number of questions have been taken on notice. You have a maximum of 21 days to provide those answers. I point out that it's a maximum. I've never yet seen any government agency produce it in less than 21 days, but I note it's available to you. There is a matter I may just raise with the committee at this point. I see some merit in us recommencing at 1:30 rather than 1 p.m. There is a press conference being held by the Premier at 1 p.m, which may well distract members and participants to some significant degree. I'm therefore just wanting to test with the committee the benefit of commencing at 1:30 and then seeking the indulgence of those witnesses. Obviously will be in their hands as to whether or not they're able to extend the additional half hour. I would hope they would, but we would understand any prior commitments they have. But I do see some benefit in commencing at 1:30 rather than 1 p.m.
I don't take objection.
Don't object.
All right. Well, then I might ask Mr. Graham if he would move that.
I'll move that way.
Right. That's been put. All in favour, all against? I'll consider that carried. So we will be recommencing at 1:30 p.m.
So given the time, I think we do have all the members here. Unfortunately, the chair is unable to make this afternoon's session. So, and I have previously been elected the permanent acting deputy chair. So I will assume the role for this afternoon's session. Can I thank the witnesses? I understand this session has been delayed by 30 minutes, which will mean that we will go until 2:50 this afternoon instead of 2:20. Now, we're going to need to swear you in. Have you got the document there?
Yes.
Okay, so perhaps Mr. Middo, if we get you to go first.
Thank you. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And Ms. Wilkinson?
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Now, I neglected to note that it is this afternoon's hearing of the Public Accountability Committee inquiry into what is known as Tahi, and we'll be hearing this afternoon from Treasury officials. Thank you very much for your time. I will now pass to Mr. Mookie to begin the questioning.
Deputy Chair, the witnesses might be invited to make an opening statement if they so wish.
Thank you so much, Mr. Mookie. Mr. Middo, Ms. Wilkinson, would you like to make an opening statement?
We don't have an opening statement, thank you.
Oh, okay. Then we'll pass straight to the to Mr. Mookie for questions.
Thank you, Deputy Chair, and thank you, Mr. Miller, for joining us as well, and Ms. Wilkinson for doing this as well this afternoon. Can I just ask some very basic questions? Mr. Miller, what is your responsibility as it relates to Tahi?
So I oversee policy and budget. So it's an area that looks after policies developed across the sector and advises the treasurer on those policies. Part of that remit obviously covers the transport cluster, and therefore, as Tahi is part of the transport cluster, it falls under my responsibility.
Okay, but you aren't the Deputy Secretary who supervises state-owned corporations, are you?
No, I'm not.
That's Mr. Gardner, is it not?
That's correct.
That's okay, thank you. I just wanted to make sure we're clear on that delineation. Ms. Wilkinson, can I just ask you the same question?
Yes.
What is your involvement?
Sorry, yes, of course. My role is I run the division in Treasury, which includes the transport branch. So I've been the customer relationship partner for transport and have worked collaboratively with them throughout the implementation.
Right. And are you part of Mr. Middar's group, or? Sorry, you have to answer affirmatively.
So yes, that's correct.
Thank you very much. And Ms. Wilkinson, how long have you been had that responsibility of the transport cluster?
I believe I took over being the Director of Transport in 2017, and I've had my current role since 2020.
And is that when you first got exposure to the establishment of Tahi?
Yes, that's correct.
Thank you. And Mr. Midhar, how long have you been in your role for?
I've been in my role since the middle of 2016, and I've been involved with Tahi since 2017.
Thank you, Mr. Midhar. It's just helpful to understand people's knowledge in time, if it's okay. Can I also, Mr. Midhar, just say, before we get into the real substance of the question, just thank you as well and your team for the answers that you provided to budget estimates on notice. They were very helpful and they were clear. I appreciate that a lot. Can I just ask you, Mr. Midhar, the very first question, what is Tahi's impact on the budget?
So Tahi, as a SOC, is reported outside the general government sector. It is accounted for in the total state accounts, and that will be the first impact of it will come through as we in this year as a state the total state accounts are finalized.
So just to unpack that, Tahi has a classification in the budget, does it not, of being a public non-financial corporation?
That's right.
And it's equally also a state-owned corporation?
That's right.
So, and in order for it to obtain its status as a public non-financial corporation, can you explain how an entity is classified as a public non-financial corporation?
So Tahi, as a general PNFC or as Tahi?
Mr. If you are, I will probably invite you to explain both in that context, if you think that there's a distinction.
So if the control and the operations are outside the general government sector, that is a SOC. And so a public non-financial corporation also has its operations outside government, but can get direction, which is not a SOC, can get direction and operations from the secretary of the cluster. But I'll let Ms. Wilkinson add to that.
So essentially, a SOC is just one kind of PNFC. The question of whether an entity is a PNFC is a matter for the ABS to determine. And it's a function of the legislative architecture within which the organisation sits, and a function of the business that it does and the governance that it has. So Rail Corp was a PNFC, Tahi maintains that classification.
Indeed. And is it the case that in order to maintain its status as a PNFC, as Mr. Midar says, it has to be independent of control of government? Is that what you said, Mr. Midar?
As a SOC.
As a SOC, it does?
As a SOC, it needs to have yes, control outside government, yes.
And what are the tests for independence that apply?
So the key tests for independence are that it has an independent board and that it being regulated under the SOC Act, that it acts with fidelity to the SOC Act, and that it's a market producer.
Are they the only criteria that is used?
It depends on whether you're talking about legal criteria, accounting criteria, classification criteria. So there are several.
I'm talking about the ABS criteria.
So the ABS criteria, there are several. I'm happy to get you all of them, but they do include market producer and separate institutional entity.
Okay. Do the ABS criteria for independence require an entity like Tahi to have a majority independent board appointed by the government who develops the strategy and operations of the organisation and operates within a commercial environment?
That's my understanding, yes.
Does it also include that it provides goods or services with customers who are free to purchase and make that decision based on economically significant prices charged?
Yes, that's the market producer test.
Yes, and does it also include the criteria that it can distribute surpluses?
Yes, I believe that's correct, but very happy to take on notice the specifics for you.
Oh, please, Ms. Wilkinson, that would be helpful. But I'll just keep putting them to you and you can tell me whether they are parts of the test or not. Equally, that it recovers the majority of its costs through sales revenue over a sustained multi-year period?
That's a specific detail that I'm not familiar with, so I will endeavour to get you the answer more fully on notice.
Okay. Is it the case that for a transport entity, according to the ABS, that in order for a transport entity like Tahi to maintain its status as a public non-financial corporation, its rail fares have to increase to a rate of majority cost recovery?
Is that your question?
Yes.
Rail fares is a different consideration. The costs and the prices are always two different things in government. So obviously we at the Treasury like to have transparency around costs, but ultimately the prices charged to the public are a matter for government. Okay.
But can I put to you, and you tell me if this is wrong, that you've nominated a majority independent board appointed by the government as being the criteria, but isn't it in fact that the key criteria for the ABS is that it makes its that it can provide goods or services with customers who are free to purchase and make that decision based on economically significant prices charged?
I believe that's broadly correct, yes.
And that equally is the core aspect that's applied in the IPART methodology, is it not, when they determine rail access undertakings? That the costs.
Yeah, that's broadly correct.
Yes, okay. Thank you. That's very helpful. Mr. Midar, can I just return to the question about Tahi's impact on the budget? Did the decision to create Tahi improve the state's budget position or cause a deterioration in the state's budget position?
Within the GGS, it made it continued. Well, it had no impact because because Railcorp was in the PNFC and it was being and all the its relevant costs were outside the GGS. So when Tahi came into being, it continued that treatment continued. So it had no impact on the GGS on the government accounts.
So just to understand this, so I properly understand your evidence, Mr. Miller. Are you saying that the decision to create Tahi had no impact on the state budget?
In 2021, in our budget accounts, the cost of Tahi, which are the majority cost of Tahi, which is the capital injection into Tahi, continued to be treated as equity, and therefore had no, which was before it was RailCorp, and now it's Tahi, and that treatment continued. So they had no, I would say, significant impact to the budget.
When did Tahi or its predecessor entity, I think which was called AssetCo, get the classification of non-financial status from the ABS?
PNFC, RailCorp has been around since, I think, 2004.
No, that wasn't my question, Mr. Miller. When did Treasury obtain interim classification from the ABS that either Tahi was to be a part of the non-financial sector?
I'm not sure that the process that was followed was so there were recommendations, or there was a review from ABS in 2015. ABS confirmed that the Tahi will remain a public non-financial corporation. So this was a continuation of the classification given to RailCorp. So that confirmation.
2015. 2015.
2015. That's correct.
Did the ABS attach any conditions to its original decision?
If I may, the ABS don't set conditions. We conduct our business, and the ABS from time to time observes the way we conduct business and forms its own opinions.
Well, did you inform the ABS 2015 or 16? I say you, I mean Treasury. That Tahi would have legislation in place by 1 July 2016 and an independent commercial board from 1 July 2018. And on that basis, did the ABS allow the classification of non-PNFSC status to proceed immediately, even though the Tahi had not yet been established?
I'll have to take those dates on notice, but there was so obviously discussions with ABS on the timing. The ABS were informed of our progress in standing up Tahi as an independent entity. I'll need to confirm when that was conveyed to them. I don't remember the exact process to date, but this is ongoing. There was ongoing conversation between Treasury and the ABS.
Well, I appreciate you taking that on notice, Mr. Miller. I'm just going to ask you one question before I pause to allow any colleagues, if they have any particular questions, to join in. Just want to put it to you again. You said that Tahi's establishment had no impact on the 2020-21 budget. But what about the 16-17 budget? Did the establishment of Tahi, or the process of establishing Tahi, lead to any budget saving from 2016-2017 onwards?
So there has been no change. Because there's been no change, and the treatment that had existed pre-Tahi with RailCorp, the financial treatment, continued. So there was no additional impact, positive or negative.
You're saying that the decision to establish Tahi 15-16 had no impact on the budget in any year since?
I'd have to go back and check the 15-16 numbers. From what I understand, that because it was already a PNFC and the equity injections or the capital injections were treated as equity, and we continue to have that treatment, there was no material change to the bottom line.
Okay, I will pause there and allow any questions. Mr. Chair, before I take the witnesses to the first tender document, I would direct them to.
Ms. Boyd?
Yes, if I may. Thank you. And thank you both for attending this afternoon. Just on that point, I understand there is a distinction between what is seen to come out of the budget and recurrent expenses and what is considered to be a capital injection, and therefore off of, sort of outside of the budget, if you like. If that ABS classification was revoked, what would be the impact on the budget?
So if ABS decided that Tahi was not a PNFC or a SOC, and then what would be the fiscal impact to the GGS? Can I just confirm that's the question?
Yes, presumably there would no longer be classified as a capital injection. Is that correct?
Yes, that's right. It's an equity injection. So then it would be, we have two choices. So the government has a couple of choices, but what it does it leave it still within the PNFC and then treat those injections as grants that have one impact? Or do we pull the assets into the general government sector and then treat treat the injection as capex, and that would have then a depreciation impact over the future. So there are a couple of options.
In the first option, if it was treated as grants, presumably then that would impact on the budget bottom line because that would come straight out of the expenditure.
Yes, and that is true for any equity injection. If it converts to a grant, then it would impact the OPEX.
So given how significant that impact would be on the budget, and whether or not we're talking about a difference in real money coming out from a sort of the way that the person on the street might see it, the money is still being spent regardless of how it's classified for accounting purposes. But given the impact that would have on the budget bottom line and the at least the perception that would create with the public, that seems to be a significant risk. Do you see a risk of the ABS classification changing?
Okay, so I can't speak for the ABS. I think what we have done through this process is ensure that we have met all of the ABS requirements and the accounting standards requirements. So that's something that we have ensured along the way, and it is now up and running as a SOC. And as it develops and builds its commercial activities, we expect it to continue to be a commercial enterprise run independently with an independent board. So we are comfortable that we've met the requirements of the ABS classification.
You said at the beginning that the ABS could come in and review the operations and to check that it's still compliant. So the implication from that is that it could revoke that classification if it didn't like what it saw in the operations, correct?
It can do that for any SOC, that's correct.
So is compliance with those criteria for the classification I guess a headline issue for Tahi? Is that something that Treasury and Tahi prioritise to make sure that you do comply? And if so, how is that done from an operational perspective?
No, I take a step back and say our role is to ensure that it meets the legislative requirement, which is what we are implementing. So that's the number one priority, to make sure that it meets it. And in doing so, it meets the requirements of the ABS and accounting classifications. So those are I would suggest, the three different things that we look at closely to ensure that Tahi, that's how we would measure success for Tahi, that it meets the legislative requirements, all the 4 objectives in there, 4 or 5 objectives in there. Plus it meets all the accounting requirements within its structure, and also it meets the requirements of a SOC as an ABS classification. Then we also have a commercial policy. It needs to comply with the SOC commercial policy also.
So just one last question before I hand back to Mr. Mookie. There was some reliance in budget estimates put on the idea that Tahi was significantly similar to the Victorian and Queensland models in terms of the ABS classification. But in fact, they're very different, aren't they?
Yeah, every state's models is a little bit different, absolutely. But they do something similar where a lot of the assets are held in a separate entity.
So if I
Yes,
may,
but with
it's the
sorry, go.
classification. The point that I believe is made at estimates is not that the architecture of every element of the business is the same, but that the classification as a PNFC is the same. So that's true for Victoria and Queensland, and it's also true for the Australian government's Australian Rail Track Corporation.
Yes, but given how different those entities are, the idea that them, that the fact that this is being done in other, or something similar is being done in other jurisdictions, is not in itself comfort that the ABS classification is correct and will be maintained. Is that correct?
We would never speculate on what the ABS's opinion would be. We simply note that the PNFC classification exists for rail asset holding entities in 3 other jurisdictions.
Right, thank you. I'll leave it there for now.
Thank you. Just on that though, Mr. Miller, are you responsible for liaising with the ABS on this?
No, I'm not. I think it's the accounting area, so it's not under my.
On notice, can you nominate the group that does that and which deputy secretary is responsible?
Okay, I'll come back to you. Yes, we'll take that on notice.
Thank you very much. Mr. Miller, I just want to return to the conversation we were having about the budget impact. Just so I understand you clearly, your evidence is that it had no impact on the budget at any point since its creation?
I've taken that as a material impact or a deviation from what used to happen, which was as a Railcorp. So the conversion from Railcorp to Tahi, there was no material change or impact to the bottom line.
And that had no impact on the budget?
So there's no material impact to the budget. That's correct.
Okay, let me put this to you. Did the decision to create Tahi cause a positive budget impact of $1.8 billion in 2015-16 and a forecast of $6.8 billion over the forward estimates from that year?
So so I'll go back the year before. So from what I understand was the injections into Railcorp were treated as equity. And so when Tahi was announced, we had a transition period where ABS continued to treat those injections as equity. So there was no change to the impact to the bottom line. The change would have happened if we had decided, or if government at that time had made the decision to either convert its status from a PNFC to a GGS, or had committed to not taking forward independent governance and moving to a soft model.
Okay. Can I, Chair, now formally table the Treasury documents that I've tendered? And
those has been formally tabled.
Yeah, thank you. And can we turn to Treasury Tender Document 003, if you don't mind? Do the witnesses have that document?
Yes. So I'm just trying to bring that up. Sorry. 003. Yes.
If you can open that document and turn to page 9, that would be helpful. This is the Cabinet submission that was provided by then Treasurer Berejiklian and still Transport Minister Constance. I'm going to read to you now directly from it at paragraph 6.1. There is a positive budget impact of $1.8 billion in 2015 and 16 and forecast $6.8 billion over the forward estimates. So, Mr. Miller, having seen that, would you like to revise your position when you said it had absolutely no impact on the budget?
So, one, I cannot comment on a cabinet and confidence document, so I can't do that. But I still stand by my previous comment.
Okay, look, I want to be very fair to you because I'm going to suggest to the committee, and the committee may disagree, that we do make findings about this. But I'm just going to put it to you that when Cabinet agreed to this, they agreed it because of the predominant reason that it would create a positive budget impact of $1.8 billion in 2015 and 16 and a forecast $6.8 billion over the forward estimates, and that reflected Treasury advice.
Well, I've got to take the point of order, Chair, or acting deputy, whatever, Chair. What is being put to this witness is what Cabinet decided. This witness, for a whole series of reasons, cannot give evidence as to the reasoning process adopted by Cabinet, including, amongst other things, putting aside any legal restraint, the very fact that the witness was not present when Cabinet decided the matter. So
To the
you
point
can
of order.
put a proposition as to what
I
this
understand.
knows,
I
but
understand,
not
Mr.
me.
Khan. Mr. Mookie, did you have any comments in relation to the point of order?
Look, I'm happy. I was eager to put the question again to the witness because it seems to contradict what he just said, and I want to be procedurally fair. But if Mr. Khan doesn't want me to do it, I'm happy to move on.
No. Look, that is an unreasonable response. The bottom line is witnesses can give evidence as to what they know. What Mr. Mookie is putting is an invitation for somebody to speculate on something which is outside their knowledge, and that is unreasonable, and it doesn't deserve the riposte that Mr. Mookie gave.
I take your point, Mr. Khan, about the reasoning and the basis for the decision of Cabinet that the witness can't be questioned about that. But it does seem that this particular statement that Mr. Mookie is drawing to the witness's attention does seem to contradict his earlier evidence. So I do think it's fair that the witness be at least given the opportunity to reflect on whether they want to stand by their previous statement, given what we have seen.
And my answer is yes, I do.
Okay, thank you. Mr. Midart, can we turn to page 10 of that document? And again, I appreciate that you might be limited, but I just do want to put this to you because you are the person who's responsible for the state budget. This document says that in 15-16, the creation of Tahi would create a positive benefit of 1.8 billion. Given that year, the actual budget result was 3.4 billion in surplus. Is it the case that half of that surplus was owed to the creation of Tahi?
So I'm going to repeat my answer because the benefits of the equity injection existed with Railcorp, and all Tahi was doing was continuing that equity injection, and the treatment of that equity injection continued as if it was a PNFC transitioning into a SOC. So the benefit would have been in 12 and 13, 13, 14, 15, 16, 17, 18.
Mr. Miller, if we are to accept your position, then we have to infer that the submission that went to Cabinet was wrong. So, because this clearly states in that year, total financial implications, positive budget impact of $1.8 billion.
So I can't comment on the Cabinet and confidence document, but it's all relative. So if I would put a hypothetical scenario to you that if the impact of not having a capital, if the capital injection or the equity injection was treated as an expense, and that was your starting point, and then if you continued treating it as equity, then there would be a benefit. So again, I'm not commenting on this document, but I'm just suggesting that seeing things out of context are a little bit difficult.
Well, Ms. Smith, I appreciate the answer. I'm just going to I was intending to put each year to you, but I suspect it might be more efficient for everybody if I put them to you cumulatively and allow you to respond at large. This document says that in 16-17, the decision to establish Tahi improved the budget result by $1.9 billion, which was close to half, a little bit less than half of the $4.4 billion surplus the state reported that year. 17-18, it says that Tahi contributed $2.2 billion in positive budget impact, and that year we reported a $3.9 billion surplus. So it accounted for more than half of the surplus there. It says as well that in 18-19, Tahi contributed $1.6 billion. At the time that year, we reported a surplus of $802 million, which means without Tahi, the state would have had a deficit in 18-19. And it says that in 19-20, it would have contributed $1.1 billion of positive budget impact. That year, we had a deficit of $6.916 billion, which to be fair is because of COVID, which would have been $1 billion worse. Basically, the inference that I'm getting is, but for the decision to create Tahi, surplus would have been lower almost by half in every single year, and we would have reported a deficit, not a surplus, in 18 and 19. Would you like to respond?
Well, I'd be speculating. So I stood by my answer, and I explained how continuation of rail cop into Tahi means that so the treatment has continued, so therefore it has been neutral as we move forward.
I understand. I won't press that matter further. Can we turn to page 3? I direct you to page 4 of this document, which is the first page of the document of the proposal. That's not the executive summary. And this is the very first paragraph of the submission. Grants currently paid to Railcorp and other agencies for investment in public transport infrastructure have in the past appeared on the budget as an expense. By holding public transport assets in an independent commercial entity, these expenses can be reclassified in the budget as a capital investment. That was the main reason why the government established Tahi, wasn't it?
So that's, again, that's not my place to comment on any cabinet confidence document. From what I understand it, I take the establishment of Tahi from the objective of Tahi, that's in the bill, and those are the principles of establishing Tahi, and as I said, it's one of the 3 different criteria we follow when setting up Tahi and supporting transport to set up Tahi.
Okay, I appreciate that, Mr. Miller. I'm just going to read you the next paragraph now. The New South Wales government has worked with the Australian Bureau of Statistics to construct the proposed Tahi so that it may be classified as a public non-financial corporation. The effect of this classification is to create a positive budget impact of $1.8 billion in 2015 and 16, and is forecast to be $6.8 billion over the forward estimates. There is no net change in underlying financial position. It is purely a reclassification of budget expenses that in effect moves them off to an off-budget entity. Tahi was created to shift costs from the budget to off-budget, wasn't it?
Again, that's as I said, from my understanding, it's setting up Tahi, which is set up a commercial entity to better manage and deliver asset management for the rail portfolio, and that's what we have been working towards.
Can I just clarify on that? We were talking before about the difference between the money coming out as a grant versus the money coming out as an equity injection, which is, of course, the whole point of this. Are you positive that prior to 2015-16, the money from the government to Railcorp didn't come out of grants, but was in the form of an equity injection?
That is my understanding, but I'll take that on notice and reconfirm with the accounting team.
Thank you.
Can I just turn to...
Sorry, can I just make another point? Just to clarify my answer. I'll certainly do that, but if it was hitting the bottom line expense, I retract that. I'll leave it as it is. I'll check and come back to you, and we'll take it on notice and come back and clarify that.
Okay, thank you, Mr. Miller. Can we just, maybe I can direct these questions to Ms. Wilkinson at first instance with your permission, Ms. Milder, if that's right, just to obey the protocol that we asked the Deputy Secretary first. I just don't want to be rude in that respect. Was it the case that Sydney Trains and New South Wales Trains do not pay to access rail assets prior to the establishment of Tahi?
So they were paid an amount from the consolidated fund that covered all their costs.
Sorry, Ms. Wilkinson, I really apologise, but your microphone, you're a bit distant. I don't know whether, I don't want to breach any COVID protocols, but I just wonder either you could speak louder or adjust the microphone.
We are in a large room. If you're comfortable with us taking them off, we can. We're in a large room here. If it's difficult for you to hear me with this on.
Look, we're hearing Mr. Miller very clearly, but Ms. Wilkinson, I have to confess I am struggling to hear you.
Okay. So the operators received an amount of money to cover all of their costs. It wasn't characterised as access fees at that point in time. Okay. And is it the case that in order to allow them to pay a commercial rate to Tahi, the budget will need to provide them an additional $800 million per annum of funding to the public transport operators? No, that's not correct.
Why do you say that?
From earlier questions, well, I won't try to infer where you've got your numbers from, but they're not ours, and I don't agree that that's correct.
Okay, but why do you disagree?
Well, we have funded the operators as much money as they need to pay their bills. And we're confident that the amount of money that we've provided to them will be sufficient for them to pay their bills across the forward estimates.
How much money have you provided them to cover their bills insofar as rail access fees and charges go?
We've paid them an amount of money that they sought through the budget process. So it's probably a matter for transport whether they break that down, but I can take on notice getting back to you with specific breakdown if you'd like. Was it circa $700 to $800 million? That number would make more sense, yes. Okay. And is it intended? Okay, so it's not 800 million, it's 700 million. But you have to keep in mind that's on top of the 1.2. Sure, but the actual, in terms of the, but I'm talking specifically to allow them to pay a commercial rate to Tahi. How much extra money does the budget have to provide the public transport operators for them to pay Tahi commercial rate? Not a significant amount, because they were already funded at a level that provided for the maintenance of the track. Okay. Is it intended that Tahi should be returning the majority of either the 800 million or the 700 million per annum to the government as dividends? No, Tahi will spend some of its earnings from its customers maintaining its assets, and it will determine what investments it wishes to make, and any dividend that will be paid in the future will be negotiated after they've completed their business plan. Yeah. Can I just take you to paragraph 2.6 of Treasury Tender Document 3, which is the same document we were referring to before. It says this, I'll read it to you. This is the Cabinet submission that Treasurer Berejiklian and Minister Constance presented. Sydney Trains and New South Wales Trains do not currently pay anything for use of the assets. To allow them to pay a commercial rate to Tahi, the budget will need to provide an additional $800 million per annum of funding to public transport operators. In turn, it is intended that Tahi should return the majority of this $800 million per annum to government as dividends, producing no material effect on the budget from this injection of money. Now, I'm struggling to reconcile that statement with the evidence that we have heard from these witnesses, because I put each of those propositions to you, and you basically, the only inference that I can get is either the submission is wrong, or perhaps the evidence might need to be revised. I would say that if you're referring to a document that appears to be from 2016, it wouldn't be unexpected for circumstances to change and assumptions to change between the point in time when that was written and the point in time when we finalised arrangements. Look, I accept that, Ms. Wilkinson, you're absolutely right. But the issue is, what was the motive of the government at the time? And I'm putting to you, let me just put it to you, putting it to you that the reason why this was created was because there was a positive budget impact at the time of inception that was thought to be $6.8 billion other than the forward estimates. And we would maintain that the objectives of Tahi are stated quite clearly in the legislation that was passed by Parliament. Sure, okay. I'm just going to return to the questions that Ms. Boyd was asking about what the impact of dissolution will be as well, if you don't mind. Unless Ms. Boyd or others want to ask any questions now before we get to that point.
Could I just jump in with one question?
Sure.
Perhaps I'm stealing your thunder. I hope not, Mr. Mookie, but I just will ask this question. If the question is, if Tahi was no longer a PNFC, so if it became an off-budget sheet entity effectively, or off-budget entity, what would the impact be on the ratings?
I mean, the state's credit ratings, I think you mean, Ms. Boyd?
Correct.
I can't see. So you think what would be the impact if all those? So there's a couple of assumptions here. You're assuming that at the moment it is treated as a PNFC and as a SOC. So the equity injections into it would then have to change, because they would be either as a capex or as a grant. So the natural impact of that would be, you're saying, would be the budget result, and would that impact the credit rating agency's decision? The credit rating agencies look at a lot of things. Certainly, the operating result is one of them, but much more closely the cash result. So this should not impact that. So I can't guess. I'll be guessing here a little bit about how it will impact, but I can take that on notice and come back with a more full answer. It might affect a metric. It may not. I don't have a clear answer on that.
That I find that surprising, to be honest. Are you saying that you don't know if it would actually have an impact on the state's credit ratings? That's not something that's identified as a risk?
So are you saying would that affect? So the credit rating agencies look at a lot of different measures. It is not one measure that tells them whether to downgrade or upgrade us. There are a number of different measures. So so what I say, that it could be a measure that could be impacted. Whether that results in a downgrade or upgrade, I couldn't say that, obviously, because that's for them. We do look at that as a risk, but obviously the operating result impact would occur within the credit agency metrics for assessment.
In my previous career, I spent a lot of time with rating agency methodology, although not in relation to governments. But I'm well aware of the very fine and fancy footwork that needs to occur whenever you're structuring any kind of transaction to make sure whether it's treated in one bucket or another bucket for rating agency purposes when they're doing their calculations of ability to repay debt effectively. It's incredibly fine. Perhaps you can take on notice whether the rating agencies provided advice at any time since the establishment or prior to the establishment of this structure. I would anticipate that they did, and that you would have sent it to them for their comment at some point. If you could take on notice any of those discussions between the rating agency and Treasury in relation to the methodology that they would apply here and what the impacts would be, that would be very much appreciated.
Sure. So I'll just make 2 points to just clarify that. One, they are aware of, so we have briefed them on TAHI and they're comfortable with TAHI. So that has been done, and I agree. Yes, we have briefed them on TAHI. On 2, the reason for my hesitancy around the impact is because there is no cash impact to government at that stage, because remember, the government is still spending the money either as an equity or as a grant. So which is why the actual impact to the rating agency's numbers is hard to quantify. I would have to ask the technical team to have a look at that, but the cash impact hasn't changed. So normally, if your budget result was impacted by a huge cash movement, then absolutely our ratings would be strongly impacted. But I think there's some impact, whether it's significant or is it material or small. I don't know at this stage. I couldn't tell you offhand. I can take that on notice.
Thank you.
Just on notice on that. Firstly, Mr. Miller, I do understand. Actually, I think your point is very persuasive, that they actually do look at the cash position of both the government and the public non-financial sector as well. Makes a lot of sense to me. But when you said you briefed them, when did you brief them?
I'd have to check with the team. I didn't personally do the TAHI briefing, so I'll have to come back. I'll take that on notice and find out the exact dates. But we do brief the rating agencies very often, on a regular basis. So I couldn't tell you which ones. It would have been during the process of setting up TAHI, but I can check on that.
Did that briefing take place at the request of the rating agency?
So we didn't have a specific. I'll need to check again. I don't think there was a specific TAHI briefing. I think we have briefed them as part of our overall briefing. We give them up to date on changes to government and progress on major government initiatives. So we would have briefed them on TAHI.
Okay, and I presume that was what, Moody's, S&P, Fitch?
Yes, and I think the last time it came out would have been sometime this year.
Okay. Do you mind just providing us a date of every time the rating agency has been briefed and which one? On notice?
Sure, I'll take that on notice.
Thank you, Mr. Miller. Can I just return to the question of this budget impact? Is it the case that insofar as the forecast savings to the budget in the cabinet submission, it's close to $8.5 billion between 15-16 and 19-20, that was in fact fully realised?
15, 16, 19, 20. So what was realised? Sorry.
Let me put it to you. I'll put it to you again. In what is called Establishment Phase 1, which went from 2015 to 2020, the creation of Tahi preserved $8.5 billion of expenses to date being recognised as equity.
Off the top of my head, I think that's possibly the amount that was made the equity injection. Sounds in the ballpark, yes.
So it did preserve $8.5 billion of expenses to date being recognised as equity, correct?
Yeah. Again, any equity injection, conversion of any equity, whether it's to any stock, if you converted that to a grant, would have a negative impact.
Okay. And is it the case in what's called Establishment Phase 2, which is ongoing, which is when Tahi went live as a for-profit public non-financial corporation, state-owned corporation post 1 July 2020, which lasts, I think this phase is meant to last from 2021 to 24-25, that Tahi is expected to save the budget a further 7.1 to $10 billion.
So it sounds like those phases that you're talking about are kind of budget phases. So we are in the current budget phase of 2021 to 24-25. I don't know. Those numbers would change every budget year, depend upon what the capital injections are. So I can't confirm that.
Okay, you can't. That's fine. And can I then take you to tender document, Treasury Tender Document 001?
Yes.
This is an update, which I think was last year. Towards the end of last year or the start of this year, I think is my recollection. If you go to the very first slide, it confirms what you confirmed, which in transition phase 1, 15 to 20, Tahi did preserve $8.5 billion of expenses to date being recognised as equity. Do you see that?
Also, I need to point out that is a cabinet in confidence document, so it could have been attached to a cabinet submission. Can't really
look. I appreciate that, Mr. Miller, but I will just confess I'm a little confused as to which certain documents have been produced that are marked cabinet in confidence, but they've been produced. Other documents, I'm just going to put it to you because there's an ambiguous status of it all, right? Like, so it's sort of, if you can't feel like you can't answer it, I accept that. But I do feel like I should put it to you, to be fair. So it says here that it saved $8.5 billion. You can't comment?
So I don't want to comment, but I want to clarify again. Equity injections, if I treat it as grants or treated as would impact the bottom line. And the number you mentioned before I looked at this, I went back and looked at this, kind of sounded in the ballpark of the kind of equity injections will be made into Railcorp or Tahi.
Yeah, sure. And it also, this document then goes on to say, confirm basically what you did confirm, which in phase 2, which we're in now, and I think lasts out to financial year 24, Tahi will deliver a further benefit of at least $7 billion to the budget to support expenditure growth within the cap. And the figure, the actual chart says it could be up to $10 billion. Do you see that?
Again, I can't comment directly on the document, but I will say when you're looking at future projections, it will depend very much about what the capital program is and how that equity is injected, how much of equity is injected into Tahi. So future projections will depend upon that.
Okay, we'll put aside the document then. What are your existing future projections saying about the budget saving that will be realised by Tahi between financial years 21 and 24?
Sorry, could you repeat the question? I was talking, sorry.
So we'll put aside the document.
Yeah.
Your current projections, which you maintain, as you said, as a person who's responsible for the state's budget. What do you currently project will be the savings of Tahi between financial years 21 and 24? So
can I just clarify? There are no savings. We are just continuing. It is budget neutral. The existence of Tahi is budget neutral since the conversion from Railcorp to Tahi.
Sure, I'm happy to rephrase it. What further benefit do you expect to the budget between financial years 21 to 24 as a result of the creation of TAHI?
So the benefit creation of TAHI will be the dividends that they eventually pay back to government, and that will depend on their business plan and the dividend projection. I don't. I'll take that on notice to see whether we have anything in the budget papers.
Okay. Just to that question about the cost of TAHIs to revert to the general government sector, has Treasury ever costed what the impact of that would be?
So we do cost because we understand the impact of converting an equity into a grant. So that's something we do as a matter of course. So yes.
So when you costed the impact of TAHI reverting to the public sector, what did your model say the impact was?
So now I'll take that on notice and try and understand what numbers are available. But really, whether for TAHI to be dissolved, that's a decision for government. So it's currently a SOC, so I'll have to take an act of Parliament to dissolve that. So that's not something that's current that we are looking at.
But you have budgeted it. You've modelled it. You just said you did.
Yeah, we did that early in the piece.
When was the last time you modelled it?
Again, I'll take that on notice. It would have been, again, I'll take that on notice.
Did you ever produce a model as to what the budget impact would be if TAHI is reverted between 2021 and 2024, and then a separate number for 2025 and 30?
All the modelling we would have done would have been on behalf of cabinet work. So there would be, again, there'd be, probably cabinet in confidence. But again, I'll take that on notice and check.
Okay. Can you turn to the last page of Treasury Tender 001 again, the one we were referring to before? And again, I'll ask the question, and Mr. Mihar, I respect whichever way you wish to answer it. Says the last slide of this presentation says impact of dissolution. And the subheading of the slide is the largest gains are in the next 2 years. Dissolution puts pressure on funding and is high risk to deliver, which is fair. But then it actually does provide those figures, which Mr. Mihar, I think you took on notice. Says here that the budget impact if TAHI is reverted cumulatively across 2021 to 2024 is $7 billion and 94 million. And it goes on to say that between 25 and 30, the impact if it's reverted is $7.5 billion, which means the total for the next 10 years, if TAHI returns to the public sector, is $14 billion. Do you agree with that? Does that align with your forecast, the models that you were putting?
I'll take that on notice and we'll check.
But that would be a total disaster for the budget, wouldn't it?
Well, unwinding any SOC would have a budget impact.
Yep, and unwinding this SOC would be specifically devastating, would it not?
Again, I'll take that. I'll take your. That's that. I'm sorry. I can't speculate on the options and the mitigation factors. If Parliament were to decide on what would happen to SOC, we would examine that situation at that time. And
no, there's two risks on this question. There's a risk is that Parliament decides to reverse it, and the other risk is that the ABS withdraws its classification. You accept that?
Sure. Yes, and yeah.
And if the ABS was to reverse its classification, $14 billion worth of costs over the next 10 years would come back onto the state's budget, would it not?
Well, I don't know what that number is, and it depends what action we took.
But if the ABS wants to withdraw its classification, as Ms. Boyd put to you, the actual impact on this for the state would be bigger than anything else other than COVID or a pandemic to hit the budget, right? This is more devastating. To lose this classification will hurt the budget more than the cost of the pandemic. So that's why I'm asking you this question, Mr. Miller.
No, I understand. I understand that, and I want to be helpful, but I do want to say So if we did nothing, if there's a reason for the classification reversal, we're not meeting some different metric or some particular standard, then we would have to rectify that. So it's not a given that is 100% guaranteed outcome, because we have lots of other tools and actions to take before something like that would eventuate. It's a risk, but we have risk mitigants. We would have risk mitigants to overcome that, and we've done everything we can to ensure that that does not happen.
Oh, look, and to be fair to you, Mr. Miller, I didn't put to you that you didn't have, that it was beyond the power of Treasury to mitigate the risk. Like, I accept you. I accept that, to be honest with you, that Treasury will have $14 billion worth of reasons to mitigate the risk. That's my point. Treasury is heavily invested in this structure because if it falls over, it will hit the budget by $14 billion.
Well, I'll take a point of order. Firstly, that actually is an assertion, not a question. That's the first. Just hold on. That's the first point. The second point is this. The question has been put to this witness at least on 2 occasions now. He has responded. Simply asking the same question again, or indeed now getting into speech making, actually doesn't advance it. So I invite the member to move on.
Well, to be fair, Madam Chair, on the point of order, proposition that the witness advanced in response was that Treasury was capable of mitigating the reasons. And I'm putting to the witness a separate question. I'm happy to rephrase it as a clear question if perhaps I wasn't clear.
You weren't clear at all.
Okay, well, I'm happy to put it again, Ms. Deputy Chair, if you wish to rule.
Then I'll invite you to put it again. I'm sure Mr. Mookie appreciates the advice on his questioning from Mr. Khan. He does actually have the ability to put the question how he chooses, even if that is multiple times over and over again. We do have 20 minutes to go this afternoon. I'm sure Mr. Mookie has other questions. So I'll invite him to put this question again if he so chooses. But perhaps, and yes, I will hand back to him for the question.
Chair, can I simply say, if he makes statements as opposed to asking questions, I will exercise my right and take a point of order, as is my right.
I feel that perhaps the resolution on this is for me to obey the superior guidance of my senior colleague here, Mr. Khan, and move on. So I'll just move on, Mr. Khan. Because Deputy Chair, your time reminder is probably the most persuasive argument I heard there. So anyway, let me move on. Can we talk about the rail access fee that Tahi is expected to charge to New South Wales Trains and Sydney Trains? And for both Tahi and those rail operators have established that it's circa 700-ish million this year. That accords with Treasury's understanding, does it not?
So that's not something at the moment that is detailed in our budget at the moment.
No,
okay.
We wouldn't go into detailed specifics, but I can say that enough money is allocated to transport in this year's budget to ensure that the operators can pay their bills to Tahi.
Yeah. Moving on, we also had, did you by any chance see any of the questioning for transport this morning, Mr. Miller?
All right, Ms. Sam, could you repeat that question again, please?
Did you by any chance witness any of the questioning to transport this morning?
Some of it, yes.
Yes, okay. So I raised with transport the report that we've previously discussed in budget estimates, which at the time Treasury said was the product of transport. I should direct my questions there, which I did. I'm talking about the KPMG report that's titled Tahi Long-Term Operating Model Assessment, which is provided to you as Treasury Tender 004. Not 003. Yeah, sorry, it's labelled 003. There might have been 2 of them, but you know the report I'm talking about, Mr. Miller?
003, yes.
This is a report the Treasury had extensive involvement in, did it not?
Sorry, Mr. Miller, are you clear on the document?
I don't have.
Mr. Mookie, are you referring to the KPMG document?
Yeah, I am. I'm referring to this one.
Operating model document?
Excuse me?
The Tahi long-term operating model document. I think
long-term operating model assessment. Yes, that is what I'm referring to. Right. That is dated 8 November 2020. This is a report that had extensive Treasury involvement, did it not?
Sorry, Mr. Mookie, Mr. Mitter, do you have access to that document?
I don't. I'm trying to bring that up now. So sorry, I haven't had a chance to.
So I would like to address, if I may, Mr. Mookie. I heard the characterisation this morning that was put that Treasury had intense collaboration or some very detailed collaboration. That document is a transport document. We were consulted on elements of it. Our view is that that document provides extremely useful information on the operating model of TAHI and on the safety requirements of TAHI. We were consulted on some thinking that the consultants did about some scenarios that might affect finances. At the time, we shared a view with them that our assumptions and expectations were quite different than theirs.
Yes, that's fair. Ms. Wilkins, I accept that. But to be fair, I think the term collaboration, I put it to them to Transport, and I think they agreed that they had collaborated with you extensively on that. But I accept that you might disagree. But my point is, it wasn't your document. Accept that. You didn't pay for it. Accept that. It's their product. Accept that. But I'm looking through the number of times Treasury officials were consulted. And Ms. Wilkinson, you're identified as attending 4 workshops in August last year, or at least 4 consultation opportunities. And I count 10 to 20 separate forms of engagement between Treasury and KPMG in respect to this report, either individually or joint with Transport for New South Wales or TAHI. I also count more than 15 specific changes that were requested by Treasury that TAHI then made. So, whilst I accept your point, do you agree with me that you were extensively consulted and had substantial input into this report?
I agree that I was extensively consulted. I do not agree that I had substantial input. If you have the documents that you seem to be referring to, you may be aware that I raised concerns with some of the assumptions that underpin scenarios that were put in there regarding fiscal and economic advice. Of course, yes. I made no comment on operational or safety matters because Treasury has no business commenting on operational safety matters. But equally, we're entitled to be considered Cabinet's principal advisor on fiscal and economic matters. And I asserted our right to have that primacy in terms of our advice. Indeed.
To be fair to Transport, they told us that this report had no bearing on safety and that it wasn't a safety report and that was beyond its scope. And as they were the authors and payers of the report, I will take their word for it. But I accept your point, Ms. Wilkinson.
I think you'll find though, Mr. Mookie, that there is a report in there from Mr. Hardwick who gave evidence this morning, and contained in that document is a paper from Mr. Hardwick that confirms that TAHI can operate safely. That was of great importance to us at the time.
I'm sure. But the point is that there was a wide divergence in assumptions between KPMG and Treasury. Is that correct?
Only limited to fiscal and economic matters.
Yes, and I count, the difference in assumptions is listed on page 63 and 64 of this report. And I count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 different variances in assumptions between KPMG and Treasury that are material to the fiscal matters that you describe, and as well. Do you agree that it's about that many?
I don't know how many it is, but I'm certainly happy to answer if that's a question.
Sure. I'll get to the key of it, right? Like, to get straight to the point. KPMG puts their preferred assumptions, and it says that the actual net impact of TAHI over a 10-year forward estimate is minus $5.3 billion. That is, it will cause if TAHI is turned on as is currently planned, it will lead to a $5.3 billion deterioration in the budget. Treasury, they then also use Treasury's assumptions and spat it out. And then Treasury, if you model the cost of TAHI using Treasury's assumptions, this report says that actually TAHI will improve the budget by $4.7 billion over 10 years, which means that the difference in assumptions, 14 different assumptions, leads to a spread of $9 billion. That's massive, you agree?
Yes, I do, and it's explicable.
Yes, and Treasury sharply disagreed with the assumptions that KPMG were applying. That's correct?
Yes.
And that led to conflict with Transport, did it not?
Led to disagreement.
Conflict with Transport, did it not?
We're public servants. We don't have fights, but we do have disagreements.
And what did Treasury do to pursue the disagreement?
We requested that they correct the errors in the report. We requested that they correctly reflect Treasury's input.
When you say we, who?
I personally did in workshops with KPMG.
And did you, Mr. Miller, ever
Yes.
pick up the phone?
Yes.
To who?
I think I put it in writing, and I've even, I think, spoken to the KPMG partner working on the project.
So we asked for that document, any correspondence between Treasury and KPMG about this report and other reports. And no such correspondence was produced, Mr. Miller. Are you in a position to produce that correspondence on notice to us, please?
I'll take that on notice.
And Mr. Miller, you said you contacted the partner in charge. Who was that?
I think the partner in charge was Mr. Brendan Lyon.
How many times did you speak to him?
Oh, no idea.
Was it multiple times?
A number of times, yes.
Okay. On notice, can you provide us any further detail?
Sure.
Did Mr. Pratt, the Secretary of Treasury, ever pick up the phone to the partner in charge?
I have no idea. I don't know.
Did Mr. Pratt ever discuss that with you?
Sorry, discuss what, sorry?
Well, did you, let me rephrase this way. Did you ever tell Mr. Pratt that you had raised your concerns with Mr. Lyons?
Probably.
Did you ever ask Mr. Pratt to call Mr. Lyons himself?
No. Listen, we've had so many conversations during the build-up of this. I can't recollect what I did or didn't say. There's a lot of detail that you're asking for.
No, it's not that many details. I'm asking you, do you recollect ever having a conversation with Mr. Pratt in which you asked him to contact the partner in charge?
Again, not to my recollection. I can go back and check my diary or something else, but not to my recollection.
In any leadership meeting that was held by the Treasury Executive, did Mr. Pratt ever disclose that he made contact with Mr. Lyons, to the best of your recollection?
I think there was contact, but again, I'd have to have a think about it, and recollect those moments. That was a while ago.
Will you take that on notice?
I'll take that on notice.
Did you ever speak to anybody else in the KPMG leadership about your concerns with this report, Mr. Miller?
I think that I noticed. We had a fair bit of at that time, so there's a fair, yeah.
Sorry, I didn't understand the answer.
I think that I noticed.
Okay. Did Treasury, to the best of your knowledge, did you ever ask Mr. Pratt to contact anybody else in KPMG?
Again, I'll take that on notice. For this particular matter on that particular report, I'll take that on notice.
Did Mr. Pratt ever disclose to you that he had contacted other members of KPMG's leadership to raise concerns with this report?
I think, Mr. Milkey, you're asking for details of private conversations, and we may need to speak with our General Counsel before sharing communications that are other people's emails or conversations. We're certainly happy to give you an answer, but it's private. Some of it may be private, and we'll just need to seek advice.
Ms. Wilkinson, I can appreciate why that might be your position, but to be fair, it's well-established practice that privacy isn't necessarily a reason to object to being asked a question here. And to also be clear, I'm not asking you to comment on other people's conversations. I'm actually asking Mr. Miller to comment on his own conversations. And the particular conversation I'm asking Mr. Miller about is, at any point, has Mr. Pratt disclosed to you that he made contact with any other members of KPMG's leadership to raise concerns about this report?
Again, I'll take that on notice. Yeah.
Did Treasury withdraw its cooperation with Transport in the production of this report?
I don't think that's the right characterisation. We have always acknowledged that Transport and whomever they hire to work with them are entitled to produce advice on transport operations and safety, which the rest of us must have regard to. That their consultant offered some scenarios around things like pricing led us to observe that they're not the government's principal advisor on those matters, and we asserted our primacy in that regard. And to that extent, we chose to give different advice that we felt was more accurate.
Appreciate that, Ms. Wilkinson. But when you say we asserted our primacy, do you mean Mr. Pratt asserted Treasury's primacy?
I think we Treasury institutionally, we certainly, each of us in our various ways insisted on our right to advise Cabinet on the fiscal impacts of their decisions.
Sure. Mr. Pratt, Mr. Miller, this question is going directly to you. Are you aware of any correspondence that the Treasury Secretary sent to the Transport Secretary in which he effectively withdrew Treasury's cooperation with Transport on the basis of what he alleged was persistent errors?
No, I'm not aware of that. We have never not cooperated or worked together with Transport. So hence.
On notice, do you wish to take on notice and sort of perhaps check your records?
Yeah, we can certainly take it on notice, but we have never not cooperated with Transport.
Well, I'll take the point of order at this stage. It is my standard, what we can call the Mookie point of order. We're getting back to the point where Mr. Mookie is talking over witnesses. So again, I ask him to go at 90% rather than at 110.
Mr. Khan is as persuasive as always, Deputy Chair. I apologise. As a result of Treasury's disagreement with the findings of this report, did the Treasury decide to then forward a report that was produced by KPMG partner Heather Watson to the Cabinet as a substitute form of advice?
No, it wasn't as so. Heather's role had been with us for a while on a couple of different fronts, but particularly on Tahi. Heather was the finance and accounting partner, so we used Heather's expertise to assure the work that we had done to ensure that we had met the AASB, so the Australian Accounting Standards Board requirements on the accounting for Tahi and the ABS classification. So that was that's exactly how Heather's work was carried out. So.
And we were exploring some of the matters that led to the commissioning of Ms. Watson at budget estimates, if you would recall, Mr. Mitter.
Yeah.
And we did ask some questions on notice as to who precisely commissioned. Do you recall that? And I think the specific question that was asked was whether that was undertaken by the Treasury Secretary. Do you recall?
The commissioning of Ms. Heather Watson? Yes.
Yeah. And the answer that came back was that the Treasury Secretary did not commission Ms. Watson. That was the answer we got back. Do you recall that?
Right. Again, I don't recollect that answer, but I can check.
Ms. Wilkinson, Ms. Watson's report is addressed to you. Did you commission Ms. Watson?
I was the official who signed the engagement letter, and so she addressed her communications through me to Treasury.
Thank you. But did you commission her? Was it your decision to engage her services?
I certainly recommended it on the paperwork. In terms of strictly who the authorising entity is, I think I have to check internally just to give you the correct answer.
I would appreciate knowing who the authorising entity was. But who told you to issue the commissioning letter?
It would have been me, I think.
But just for a little context, Ms. Watson was working with us at the time on a range of issues across the whole of the sector. She is regarded as a leading expert in the application of accounting standards in the public sector. We were already receiving advice from her on a number of issues. She was working with colleagues in our accounting policy team. It was appropriate to consult her on some technical matters.
I did capture the budget estimates and budget estimates in 2019. I think we were looking at two leasing standards and the service concession standards, and that included Tahi and Ms. Watson was working on that project, and her expertise was on display on how and the advice that was being provided. We then extended that into Tahi to provide us with her expertise on the Tahi project, and that became an additional subset to the work that she was doing.
I appreciate that, Mr. Midart. And look, to be fair, that is very similar to the answer you gave at estimate. So, like, I'm not disputing that she brought expertise that the Treasury found valuable. But, Mr. Midart, at estimates, you said that she was handpicked. I put it to you: was she handpicked? You said yes. Who handpicked her?
I'm happy to take responsibility for that because of the work that she had done. That was through this and the advice that she was providing, the detailed knowledge that she had. We were comfortable to use that expertise, and I was comfortable to use that expertise on Tahi.
Thank you. I appreciate that, Mr. Midart. That helps identify who the official was. I am going to pause there, Deputy Chair, and ask if my colleagues have any final questions in the remaining 2 minutes, because I'm eager not to breach Mr. Khan's rule.
A very quick one, if I may. We talked before about how there's no real difference in terms of the ultimate amount of money spent by government, whether it is in the form of an equity injection or a grant, the money going to Tahi. Do you have the total costs involved so far in setting up the Tahi structure? Is that something you could take on notice? And I would like it to include consultants' fees, the cost of recruiting board members, the board members' salaries, the whole additional cost of setting up this structure. Are you able to provide that for me on notice?
Yes, we can take that on notice and provide those costs for you that have been incurred by Treasury. Yes.
Thank you. And just one final question: we had quite a discussion with previous witnesses about sort of what the purpose of setting up Tahi was for, and whether or not it really is just a massaging of figures to make budget look better. From your perspective, is there any benefit to passengers, to people on, sort of people of New South Wales from this structure?
So better asset management means direct results in performance for the user, and making getting better delivery of stations and land owned by Tahi absolutely has a direct benefit to passengers on our rail services and others that use the assets that are being managed by Tahi. Having a dedicated asset manager, I think, has a great benefit to, I guess, people of New South Wales, including passengers of the rail network.
So it's aspirational. It's
Chair, that seems to be a great point to end on. It being 250.
Thank you very much for the reminder, Mr. Khan. Yes, I too was very closely watching the time. Can I thank very much our witnesses for their testimony this afternoon and for their time and for their flexibility given today's events in slightly delaying our hearing. I note that you have taken quite a number of questions on notice, and the Secretariat will be in contact with you about providing answers for those. And that draws the hearing for today's Tahi